Open this public hearing of the Legal and Constitutional Affairs Legislation Committee for the Home Affairs Legislation Amendment 2025 Measures Number 1, Bill 2025. I'd like to begin by acknowledging the traditional custodians of the lands on which we meet today, and I'm going to pay my respects to their ancestors and elders past and present. I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. On behalf of the committee, I welcome any traditional owners that are here today. For anybody participating remotely, I'm the chair of the committee, Senator Jana Stewart, and joining me today in person are several senators who you can see the name tags in front of them, and I'm sure who will introduce themselves. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. As Chair, I'll be particularly vigilant in ensuring cultural safety for First Nations people and culturally and racially marginalised groups during these proceedings. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you're a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphones to assist Hansard to record proceedings. Okay, I now welcome representatives from the Department of Home Affairs. Thank you for taking time to speak to the committee today, and particularly at such short notice. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state should not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. All right, now we can go to you for the Hansard record. Could you please state your names and the capacity in which you appear?
Certainly. Thank you, Senator. My name is Claire Sharp. I'm the Head of Immigration from the Department of Home Affairs.
Thank you.
Michael Burke, Acting Deputy Secretary, Immigration Compliance Group, Home Affairs.
Thank you.
Good afternoon. Ben Biddington, First Assistant Secretary, Offshore Programs and International Cooperation.
Peter Frank, Assistant Secretary, Immigration and Citizenship Litigation.
And Kevin Cunnington, Assistant Secretary, Legislation with the Department of Home Affairs.
Thank you very much. Would you like to make a brief opening statement before we start?
No, thank you, Senator.
Great, we can proceed straight to questions, and I'll go to Senator Cash.
Thank you very much, Chair, and thank you for attending tonight at such short notice. It is greatly appreciated, but we've done the dance before, so that's the good news. So could I just go straight to, in terms of this bill, obviously there's been discussions between the government and the opposition in relation to its passage and the reasons for its passage. Why is the bill so urgent?
Thanks, Senator. I might start and then I'll hand to Mr Frank. This bill does two things primarily. The first of which is that it will confirm by putting on the face of the law that procedural fairness is not owed in three very particular situations. Those three situations are in relation to actions taken pursuant to a third country reception arrangement. That's following a recent single federal court judgment in TCXM. The second is when we are issuing a removal pathway direction to an individual. And the third situation is where we seek to use or disclose criminal history information to support another decision under the Migration Act. We need this legislation to pass quickly because particularly the first of those grounds, there are arguments being made in the court by the first three individuals who are subject to the interim third country reception arrangement that procedural fairness is owed. As I said, we have been arguing in the court that it isn't owed. The Commonwealth won at first instance. That matter is on its way to being removed to the High Court, and we would like to see this matter put on the face of the law before that matter's timetabled in the High Court.
Yeah, and so that was going to be my question. In terms of the timetabling for the High Court, when is the earliest that can happen?
Senator, that will really depend on how quickly the bill passes. The High Court understandably doesn't like to hear matters when the law is still in flux. And so my expectation would be, obviously, it'll be a matter for the court, that it wouldn't list the matter for a final hearing until the position of the bill is known with some more clarity.
So at this point in time, you don't have a High Court date?
No.
No, okay. Has the application to remit to the High Court actually been made?
It's been filed with the registry, yes. I don't know if it's been accepted yet. There have been some paperwork issues, or I can put it that way.
Okay. So in terms of the urgency and the passing of the bill, is there a specific deadline by which it needs to pass? In other words, if it doesn't pass, all hell's going to break loose.
I don't think we'd put it in terms of all hell will break loose. As I've said, we've already won at first instance in the federal court. By this bill sitting in the Parliament, I think we will see that the High Court will be reluctant to timetable it while the law is uncertain. So it will delay removal. The individual concerned is in immigration detention, so I don't think it's right to frame it as all hell breaking loose.
No, understood. So the individual is in immigration detention, and I will turn to that shortly. So just tell me, what are the consequences if we don't pass the bill? Tomorrow is the obvious date. If we don't pass tomorrow, we rise and we don't come back for some time. Will the person remain in detention either way?
That particular individual, yes. What I will say about that is that it will also leave a position of uncertainty for any further individuals who may be subject to the expanded third country reception arrangement that's recently been agreed with Nauru.
And I do want to pursue that shortly. I just need to understand in relation to the High Court, though, are you effectively saying that the High Court is deliberately delaying listing a matter pending matters in the Parliament? Because if this is true, this is a very new situation. So I just need to be very clear here. Is that your evidence?
No, Sorry, Senator?
I thought your evidence was they'd be mindful. Be something they'd take into account.
My evidence before, I think, was to the effect that the High Court is typically reluctant to hold a final hearing in a case where the underlying legal issues in that case are in flux for whatever reason, including that there is legislation before the Parliament that could impact the issues in the case.
And perhaps it would be better to turn it around and characterise what would happen if the bill did pass tomorrow. That would smooth the way for us to seek a timetabling order very expeditiously thereafter and increase the probability of a hearing this year.
So at this point in time, there may not be a hearing this year. So can I then ask, what are the consequences if we don't pass the bill tomorrow in terms of people on the street? The cohort.
The cohort as a whole. Senator, the purpose of the bill is to clarify the position at law that the federal court at first instance has said is the law. A failure to pass the bill does not prevent us implementing an expanded third country reception arrangement.
Yes.
It means, though, that the argument about procedural fairness will likely be run by anyone we do detain, and they will seek injunctions preventing their removal using that argument, as well as possibly others. So it does not prevent us commencing the process of applying for visas, people's bridging visa R's ceasing and then being detained, but it in all likelihood would contribute to a longer duration of stay in Australian immigration detention while they challenge while they challenge.
So does it affect? So I'm just trying to understand. So it doesn't actually delay anything as such.
Well, it will. One of the primary purposes of the bill is to put on the face of the law that procedural fairness is not owed in two places where it is our position it is not owed, and that, as I said, a single federal court judge agrees with us it is not owed. However, if we don't put it on the face of the law, applicants will continue to argue that it is owed, and until that point of law is settled, I don't think we'll be able to effect the removal.
Right, so that's no, it doesn't delay anything as such though. You could continue doing what you are doing.
It does not delay the detention. It in all likelihood delays the removal.
Okay. Just on the detention, I just need to get my head around this. Can you just confirm, so we obviously have, I'm going to refer to it, it's a third country reception arrangement?
Yep.
Okay, with Nauru. The third country reception arrangement is to take, I understand, is it 280 individuals from the NZYQ cohort?
The memorandum of understanding that was signed last week doesn't specify the number of individuals. It is an agreement pursuant to the provision in the Act to consider applications from the Australian Government for people in this cohort and for Nauru to grant visas pursuant to that based on their decision about whether they would take
so
them
there's
or not.
no figure. Right, so they could take zero?
They could.
Right, okay. If they determined they would take zero, how does that impact the figure of $408 million that's been publicly reported for the first financial year alone? Do we hand over the money before they make a decision?
No, we don't.
Right, and I'll explore that okay, shortly. In terms of the 280 individuals then, so now we know the Memorandum of Understanding doesn't actually have a figure, so ultimately, if they chose not to, they don't have to take anyone. Just in terms then of the 280 individuals in the NZYQ cohort, how many of them are currently in immigration detention?
By definition, a person can't be NZYQ affected and in immigration detention.
So could you give me a figure then in answer, as opposed to, I understand but what's the figure then?
Well,
how many of the 280 are actually in immigration detention?
Zero, Senator.
Thank you. Zero. Okay. So they're on the streets at the moment is what you're saying? Okay. And just remind me, reminding myself in terms of the previous bills that we've dealt with and questions we've asked, and we're now at this iteration of trying to clean up a mess. Just remind me, zero, why are they not in immigration detention?
Because in NZYQ, the High Court found that a person for which there is no real prospect of their removal becoming practicable in the reasonably foreseeable future cannot be detained consistent with Chapter 3 of the Constitution. Detained in immigration detention, I should say.
So, and I do apologise, just I used the figure of 280. Could you just confirm, is it still 280 or is it 354? What is the cohort we're talking about in terms of what could potentially go to Nauru?
It's 354.
354. Okay, so there are currently 354 individuals from the NZYQ cohort. They're not in immigration detention because there was no reasonable prospect of removal. Now, you've signed a memorandum of understanding with Nauru. The government and the minister issued on Sunday the 16th of February 2025 a media release stating Nauru will resettle members of the NZYQ cohort as part of a new arrangement with the Australian government. The government of Nauru yesterday issued long-term resettlement visas to 3 members of the NZYQ cohort. Will resettle members. So is there now a real prospect that these 354 individuals will be on a removal pathway?
So, Senator, the way the arrangement works is it establishes a framework. Australia can then apply for a visa apply to Nauru for Nauru to consider whether to grant an individual person a visa. If Nauru grants a visa to that individual person, then the person's bridging visa R will cease automatically. That was the effect of the Migration Amendment Bill last year, because the person has a visa with a long-term right of stay to another country. They automatically, as a matter of law, they're no longer NZYQ affected, as you've reasoned. You are now removable, and they become an unlawful non-citizen and can be taken into immigration detention and placed on a removal pathway.
But isn't the fact that you now have a deal with Nauru, I mean, the minister's announced the deal on the 16th, as I said, doesn't that now give you a basis to re-detain the 354 individuals?
No, Senator, because the way the arrangement is established, it doesn't operate on a principle that every person automatically falls within scope. It is a matter of we put forward a visa application and Nauru, as a sovereign state, considers whether to offer that person a visa or not.
I just need to understand this. So even though I'll call it a deal, but to use the language, it's a third country resettlement arrangement with Nauru. This is a resettlement arrangement that has been announced. We'll then go through the implications now of the $408 million in terms of the fact that we now know that despite there being 354 members of the NZYQ cohort, Nauru doesn't have to take any of them. So I just need you to clarify now, even though there is a deal referred to as a third country reception arrangement with Nauru, are you saying, though, there's still no reasonable prospect of removal?
Senator, what we've created through the third country reception arrangement is an option to put people on a pathway to removal.
Now this is interesting. You said an option. I would have assumed you're going to exercise the option in relation to 354 people, not you personally, the government. I would have assumed personally, given concerns for community safety and what some of these people have done, you would have exercised as the government the option already to start detaining them. So has the government put in place any steps to start detaining any of these people?
Senator, with the arrangement signed on Friday, work is underway.
So work is underway. What does that mean? I'm so sorry. What does you have always brilliant at the briefings. You have been always absolutely outstanding.
Sorry, Senator Cash, can I suggest that we come back to because you're going to open a can of worms on what work is underway means? Can you take this opportunity to rotate the call and go to Senator Cox?
Thank you very much, Chair. Can I start with part of the bill that focuses on the removal of unlawful citizens? Can you explain to the committee the immigration process from the point in which an individual submits a visa application through to the point at when an individual would become subject to the removal from Australia?
Senator, you'll appreciate it varies from case to case, but in broad terms, a person will obtain a visa to come to Australia. Usually they wouldn't have any sort of criminal history at that stage, otherwise typically that visa would be refused. Once they arrive in Australia, they would perhaps engage in criminal offending and come to the attention of the department. They might commit an offence, for example, where they're sentenced for a term of imprisonment of over 12 months or more, which would engage the mandatory cancellation provisions in Section 501 of the Migration Act, and their visa would be cancelled at that point. A person in those circumstances would have the opportunity to make representations to the decision maker as to why the cancellation of that visa should be revoked. That's a very broad-ranging process. It can be literally any reason that they wish to put forward as to why the cancellation of the visa should be revoked. If the cancellation is not revoked, and that decision is made by a delegate, as most of them are, that person then has the opportunity to seek review of that decision in the Administrative Review Tribunal. Again, they'll be afforded procedural fairness through that process, including a full hearing where they're entitled to be represented if they wish. If they're unsuccessful again at that point, they can seek judicial review of that decision. Typically, that would be in the federal court. Again, they're afforded procedural fairness and entitlement to a hearing. And from there, if unsuccessful, they can pursue appeals first to the full federal court and ultimately seek special leave to appeal to the High Court.
And I might just add that just in that scenario, if you imagine that was a student visa with the original visa, the person could then apply for a different visa type and they would go through those steps again, and that's not an uncommon pathway. So, for example, someone would come in on a visitor or a student visa, find it cancelled in the circumstances Peter has outlined, and then apply for protection and go through the steps, as Peter outlined, of consideration of the visa at primary, merits and judicial review. And that, Senator, is why it can take many years for somebody to find themselves in a position where they're finally determined and there is no longer any lawful right to remain in Australia.
So essentially...
Sorry, can I just interrupt? We've had some media into the room. Just if there's no objections from the committee...
the normal rules.
Yep, normal rules apply. Yep, thank you, committee members.
Thank you. So thank you, Ms Sharp, for clarifying that. So essentially there are many opportunities for procedural fairness to be exercised in all of the process that Mr Frank has explained if someone then changes to a different visa and a different process then starts to unfold as part of that. Is that correct?
That's right. And that's the way the system has been set up since the migration reforms of the early 90s. We've got a universal visa system. It's the visa that supplies the sole right to enter and remain in Australia. And that's the sort of the licence or permission, if you will, for a non-citizen to remain in the country. And so when a visa is ceased or when a visa is cancelled, a non-citizen becomes an unlawful non-citizen, and then there are legal duties on officers of the department to detain those people and then in certain circumstances to remove those people from Australia.
Right. I'm really keen to understand which part of the immigration process is impacted directly by these changes, and why does it remove procedural fairness? So I think you've touched on that, but could you expand for me on that?
Well, the short answer is it doesn't, in that, as Ms Sharp mentioned earlier, the federal court has found that procedural fairness already doesn't attach to these third country reception arrangement processes. That's consistent with the broad scheme that I just outlined, in that it's the visa that's the permission to remain. You're afforded procedural fairness in decisions to apply for or refuse or cancel visas, and that's where you have your say. And then from there, detention and removal from Australia are, by operation of law, their legal duties rather than discretions or decisions in the sort of ordinary sense.
Yeah. And, I mean, who will be affected by these amendments should this bill pass?
The amendments that relate to the third country reception arrangement will obviously mean that individuals who for whom their bridging visa R ceases because they're granted a Nauruan visa will be the people within scope. So not, the third country reception arrangement scheme is designed to provide a pathway to remove people who have no right to remain in Australia, who cannot be removed to their country of origin. That is, by definition, more or less our NZYQ cohort. And then the particular provision here saying there's no procedural fairness in relation to third country reception arrangements will operate on those people for whom the Australian government applies for a visa and their Nauru accepts and their bridging visa R ceases.
Okay. So will procedural fairness apply again, I suppose, is the question, at the other side in relation to the Nauruan visa? Like, will they get procedural fairness at that end?
No.
No. Okay. Can you explain to me what procedural fairness processes would normally apply to an individual who has no rights to remain in Australia and is subject to removal?
None, Senator.
None?
None.
Okay. Thank you for clarifying that. And does this mean that the government can remove people basically without warning?
Technically, yes, Senator, in that there's no statutory requirement in the Act that notice be given. As a matter of policy and in practice, notice is given, typically at least 14 days, sometimes less when there are good reasons for that.
Can you just outline what those reasons might be for us, Mr Frank? Like, can you give an example to the committee?
The one that comes to mind would be where giving a lengthy notice period might mean that the non-citizen is a risk to themselves or others. That's a classic example, but it's fairly exceptional circumstances where at least severely reduced notice periods would be given. 2 weeks is the standard.
Okay. Thank you. Thank you.
It might be worth just clarifying here that this bill, so the bill that is in question, it doesn't create any new powers for the Commonwealth. It doesn't change the status of any non-citizen as a result of the bill. It doesn't change who is liable for removal or who is on a removal pathway. So I'm not sure, some of your questions were sort of asking those things, but I think it's important to recognise that the bill isn't creating new powers or changing people's status. It is just about, clarifying, as Ms Sharp said, on the face of the Act, that there isn't procedural fairness where hitherto we would not have expected that there would have been procedural fairness afforded for those particular actions, recognising Mr Frank's evidence that procedural fairness has been applied at many stages throughout what in some cases can be quite an extended visa journey.
And we are talking about unlawful non-citizens, right? Like, just to clarify that.
We are talking about people who have reached the end of those processes and who have had access to both procedural fairness through visa grant decision or visa refusal decision, visa cancellation decision, merits review, judicial review, who, having gone through all of that process, it's been determined that they do not have a right to remain in Australia in an ongoing way. So we're kind of at the end of the road for those people. There is no pathway to remain in Australia for them. The only pathway available is their departure.
Okay, great. I'm just going to check with the chair how much time we've got and whether I'm passing the
For another couple of minutes.
Yep.
I can share before some natural pause time.
Yep.
Okay, Senator Cash.
Thank you very much. If I could just turn to my previous line of questioning. If I could just summarise where I believe we've got to, and then I can continue on. So just in terms of the evidence under the Memorandum of Understanding, there are three... So Nauru doesn't have to take any one of the NZYQ cohort, even though we've announced a $408 million deal. But they don't have to take anybody should they not want to. Correct. It's zero. The answer is
that is correct.
Zero.
Obviously, if that were to occur,
Yep.
the parties would cease the MOU.
Understood, and we'll pursue the cost in a little while. But what you're saying is Nauru could actually say no to, for example, I'm going to use the term, the really bad ones like the murderers, the rapists, the pedophiles and the contract killer, if they wanted to, and they would remain here in the community.
That is possible.
Thank you very much. Can I also confirm that the government doesn't have enough confidence that there is a reasonable prospect of removal to take any one of the cohort from where they are at the moment in the community on the streets and put them in immigration detention?
I wouldn't say that we don't have confidence. It wouldn't be lawful, Senator. The Migration Act, as amended last year through the Migration Amendment Act 2024, set up a framework for us to implement this arrangement. And it's very clear, if you work your way through Section 76 AAA, how the Parliament has directed us, if you like, to implement this. So we needed to enter into the overarching agreement with Nauru pursuant to Section 198 AHB. We apply for the visa, and only when a visa is granted by a foreign government does the bridging visa R cease and they become unlawful.
But again, at this point in time, even though you've made the announcement that there is the third country reception arrangement with Nauru, the government still has not made any attempt to go out and get any one of those 354 people.
I think what Ms Sharp is explaining, Senator, is that the, to use your terms, that the going out to get these people, to put them into detention, so to detain them, must necessarily follow the granting of a visa. That decision rests solely with the government of Nauru. So the Australian government is not the decision maker for whether Nauru grants a visa to a foreign national. Until such time as that visa is granted, the individual has retained their status as NZYQ affected and cannot, under law, be held in immigration detention.
Okay. When do you expect to get the visas for these individuals? And can I just confirm it is 354? Is that the affected cohort is 354?
The number of BVR holders is currently 354.
Yeah, so yes. So when do you expect to get the visas for these individuals?
Senator, we expect that this will happen on a rolling basis, commencing fairly soon.
When you say fairly soon, has the government applied for any visas yet? Not yet.
No. I do note the agreement was only signed on Friday last week.
And I, with all due respect, and thank you, with all due respect, just on behalf of the Australian communities, I'd also note that there are murderers, rapists, pedophiles and a contract killer that I personally would have already applied for a visa for, but I understand what your evidence is. Will the government be urgently applying for 354 visas?
Senator, it's important for this arrangement to succeed that that people are moved over there in a planned and steady way.
What does planned and steady mean, and is that in the Memorandum of Understanding?
No, it's certainly, and Mr Biddington might be able to discuss this more with you. It's certainly been part of the way we've been discussing how the purpose is that people will move to Nauru, they will become long-term residents and part of their community. We want that to succeed in a way that's sustainable for Nauru, which doesn't mean moving a really large number of people in one hit. It means moving people, as I said, in a planned and steady way.
But drill down further on that in terms of the ability of the government to actually bring people back into detention because there is a reasonable prospect of removal. Why would you not apply for all 354 visas? The Nauruan government could give 0. I understand that. They also could give 354, which at least then means for the Australian government, if I accept the evidence that you've given, and I do because it's the evidence, You're saying it still needs to be done in a planned and steady manner. I accept that, if that's the discussions. But you've got 354 people where, quite frankly, they belong behind bars or in immigration detention. As I said, like the murderers, rapists, pedophiles and the contract killer. So I just need to understand, when you say planned and steady, I hope that doesn't mean that the government's not going to be applying for 354 visas straight up so they can get people back into immigration detention.
Senator, the other constraint on doing 354 people at once is the capacity of and safety of our officers in the kind of operation we need.
So what does that mean? Take me through that.
Mr Biddington might be better.
Thank you, Mr Biddington. I appreciate that.
Yes, thank you. So, in terms of operational planning around the location and detention of a person who has a BVR.
So, are we talking the 354?
Yes.
Yeah, but by 354, that way I know we're talking about the same thing.
If we take an individual who's representative of that cohort,
a murderer, a rapist, a pedophile, or a contract killer, or others. There are others as well.
So that particular person holds a BVR, and the BVR ceases at the time that they obtain a visa for long-term stay in Nauru.
So I missed that. Bells up, making it more difficult to hear. The BVR...
Yeah, the bridging visa R ceases at the time that the person is granted a visa for long-term stay on Nauru.
Right.
And is notified of that issuance of a visa.
So until that time, they remain at large in the community, or they remain in the community under the BVR?
In accordance with the conditions of the BVR, yes.
So my next question then goes to, big fan for on the announcement. If I go back to exactly, if I look at what the press release actually said, Nauru will resettle members of the NZYQ cohort as part of a new arrangement with the Australian government. Certainly the press got very excited. What is the end date? Is there an end date for this agreement?
Nauru issues 30-year visas.
Right.
And
no, sorry, I apologise. In relation to the 354, is there an agreement? This will happen within 6 months, 12 months, 24 months. Is there no agreement? It could take 10 years.
There's no deadline on us to apply for the visas. But what I would say is that both nations it's in both nations' interests to move through this as efficiently as we can. It's in Nauru's interest because money doesn't flow until people arrive, and it's in Australia's interest for some of the reasons you've just outlined.
But they still have the right, once they understand properly what each individual is their profile, they still have the right to say no. The bit that I just want to explore, you said the restriction on applying for visas was due to the capacity and safety of our officers. Can I just get you to explain that more fulsomely?
Yes, thanks, Senator. So I was explaining there's effectively a two-step process for the person to become an unlawful non-citizen, and the operational response for officer safety needs to be timed around that notification component and then the detention of that person. It's a really critical gap in a sense because at present, people subject to BVR conditions have BVR conditions.
Yes.
But at the time that a person has that BVR ceased, they become an unlawful non-citizen and therefore not subject to those conditions. So the timing of a warrant, and typically it would be done under a Section 251 warrant under the Migration Act, that warrant only applies to a person who is an unlawful non-citizen. It doesn't apply in relation to somebody who holds a BVR. And therefore, operational timing to be able to effectively manage those two things simultaneously, the ceasing of a BVR, a person becoming an unlawful non-citizen, the application of a 251 warrant, the location and detention of that person, that can be a very short process. As such, the operational planning around that is quite detailed. It takes into account the safety of officers of the Australian Border Force, and it takes into account the safety of the individual who is subject potentially to that warrant.
Do you know at this point in time the location? And I don't mean they're in a particular state. We know that. Do you actually know the physical location of each of these 354 people?
As part of the bridging visa R conditions, they're required to report their address to us, their residential address, their place of work. There's quite detailed reporting requirements built into the bridging visa R conditions.
Has anyone breached that? Or is anyone in current breach of that in the caseload of 354?
We would need to take that on notice. I didn't bring that.
We've got an ability to do that, so that's not a problem at all. You also gave evidence, or you just said, it's in Nauru's interests to take people because money doesn't flow until people arrive. Can you explain that? Are you saying that until someone leaves Australia and touches down on Nauru, not $1 will flow from the Australian taxpayer? Is that the deal, is it?
More or less with one exception, and that is we will pay a visa application fee.
Yes.
But beyond that, that's right. The payments that the President of Nauru referred to last week only become payable when the first person arrives on Nauru.
And just in terms of the per person rate, plain English is what is the going rate per person? So when someone touches down, what is the agreed amount that will be transferred over to the government of Nauru?
Senator, it's a bit more sophisticated than that. So if you would bear with me, I might explain the payment model.
Thank you.
So the President of Nauru, I think, mentioned this in his comments to the Parliament that have been reported in the press, that the majority of funds will be placed in a trust. The trust will be governed jointly by Australia and Nauru.
So hold on, now I'm confused. The majority of funds will be placed in a trust. So can I just ask, perhaps we take a step back.
Yep.
The figure of 408 has been reported. I don't know if that's true or not. So what I will ask you is, what is the total cost of the third country reception arrangement with Nauru?
So in the first year, Australia has committed to Nauru it will pay $408 million.
So that's in the first year?
Correct.
Okay. So is there any other monies that are going to be flowing? Or is the total deal 408, and if it takes 10 years to effect it, you're only getting 408?
No, Senator. Then there's a payment that'll be in the order of $70 million for each year thereafter.
For each year thereafter. Is that regardless of how many go? So, for example, I only end up taking one.
Senator, this is where the trust that I was starting to talk you through becomes very relevant to this arrangement.
Okay.
So, and Mr Whittington, feel free to come in with additional detail. What we are doing is establishing a jointly governed trust fund with Nauru. That will have assurance, like robust assurance mechanisms and rules around the drawdown of it. Of that 408 million, is it 388 million will be placed in trust. 20 million will be paid to Nauru to support them with set-up costs associated with managing the cohort on Nauru.
What happens if they take zero? Do they still get the 20 million?
I'm going to rotate the call. You can come back to
We'll come back. No, we've got a long more time to go.
Sorry.
We've got till midnight.
Yeah, with your indulgence, can I just quickly correct some evidence I gave in response to one of Senator Cox's questions earlier? I said the standard time frame for to give notice for removals is 14 days. It is in fact 7 days. Apologies.
Thank you for that. Senator Shivridge.
Well, thanks, Chair, and thanks all for attending this afternoon and evening. I just might start by tabling submissions from the Human Rights Watch, New South Wales Council for Civil Liberties, Law Council of Australia, Refugee Council of Australia, Asylum Seeker Resource Centre, the Asylum Seeker Centre, the Human Rights Law Centre, and also a joint submission from multicultural communities, including the South Sudanese Community Support Group, South Asian Foundation Australia, the Arab Council of Australia, Africa's Youth and Community Services, the Grand Parishioner Committee, the Hazara Cultural Association, the Tamil Refugee Council and the Iranian Women's Association, all of which opposed the bill, and I provided copies to the Secretariat.
Thank you.
And I'd seek table and have them.
Thank you. I'm just going to call a quick private meeting for the committee, if that's okay, just to consider these documents.
We'll suspend
Suspend for 5 minutes. And Senator Shoebridge, you've got a change to the tabling of documents.
Well, look, I tabled them all, but I'll table them in two separate batches. Yep. One which is all bar the ASRC one, and I'll just do that now. And I understand that's accepted for tabling.
That's accepted by the committee.
And I'll separately table the Asylum Seeker Resource Centre. I understand, Chair, you want to check some of the footnotes for some of the propositions made. I hope that can be done as soon as possible, but I'd also
We
like
will
that
endeavour to do
tabled.
that. Thank you, Senator Shearidge.
And I might ask, just in the course of the hearing, to assist matters, if copies could be provided at least to Ms Sharp of those, and we'll get to them in due course. Yep.
Thank you.
Ms Sharp, I think, have you had a promotion since I last saw you?
I have changed, yes, I have changed roles. I'm no longer the head of legal, Senator Shearidge.
Congratulations.
And Senator, I just would note I haven't seen this before, so I haven't read it.
Yeah, so I'm not going to go to them straight away.
Excellent.
Just to clarify the MOU with Nauru, is it expressed only to apply to the NZYQ cohort? Because you said it could be, you said that there wasn't a number set in it. It could be naught, it could be 10,000. But what is it expressed to apply to the NZYQ cohort?
I would need. Do you know that?
Senator, not specifically referencing the term NZYQ, but it is deliberately in relation to a third country reception arrangement, and the third country reception arrangement is defined in Section 198 of the Migration Act.
Yeah, so this goes back to the laws that were passed at the end of last year establishing the third country reception arrangements, and the MOU references, does it, I assume, third country reception arrangements?
It does.
Yeah, and you recall, Ms Sharp, last time we had a discussion about that urgent legislation, and you indicated that the people who are potentially caught within the scope of third country reception arrangements went well beyond the NZYQ cohort. Do you remember that question and answer?
I think you need to understand the scheme as put through in the Migration Amendment Act last year, put in place Section 198 AHB and Section 76 AAA, which talks very much about the cessation of a visa, of a bridging visa R, which is the visa granted to those commonly referred to as NZYQ affected, upon the grant of a visa by a third country pursuant to a third country reception arrangement.
Yes, but I think it was your evidence actually in the last hearing, you said that the scheme that was being set up for third country, for these third country arrangements, and I've got the numbers here, it was 4,485 people on a BVE under departure arrangements. The number may have changed, but
I think
still covered.
That evidence was relating to the definition of a removal pathway non-citizen.
Yep.
So removal pathway non-citizens, that definition is relevant to a separate power that this bill does operate on, which we can go to, but removal pathway non-citizens was a concept introduced in the Removal and Other Measures Bill to enable the giving of directions to particular people to participate or take actions to support their removal.
And one of the powers in this bill is to remove the rights for natural justice in that process.
Yes, but that does not have anything to do with the third country reception arrangement.
So in terms of that aspect of the bill, which you're removing natural justice for, that's that cohort that you were talking about in the previous hearing.
The removal pathway non-citizen cohort.
So this bill would remove those natural justice rights if they existed, and I understand you contest that, although maybe you don't. I'll start again. This bill would expressly remove natural justice rights from people on a BVE under departure arrangements, correct?
As it relates to the giving of a removal
direction.
pathway direction, and I just want to be clear on that, since that those directions, a failure to comply with one of those is a criminal offence.
Yes.
And in order for us to successfully prosecute an offence of someone failing to comply, they have the ability to run a reasonable excuse defence.
Yeah.
If we were not to follow a pathway that enabled them to ensure they fully understood and we took into account information, we wouldn't get a prosecution up. So what we're trying to do with removing procedural fairness from that particular power is to ensure that we are working within the criminal conviction system and not also at the same time needing to comply with administrative law.
Well, you see, you're removing natural justice from a direction that can be given by the minister, which if not complied with, could see someone go to jail. That's what you're doing, isn't it?
Yes.
Yes, all right. And the people, the subject of that direction, who can be the subject of that direction, are the some 4,500 people on a BVE departure arrangement? That's one category?
I don't have the precise figure, but that certainly it could apply to a BVE holder with the departure criteria.
I'm happy for you to give updated numbers, but I'll just run through the numbers you gave at the end of last year.
Certainly.
986 people who were then in detention, so that same category, still have natural justice removed before a direction can be given, which might see them in jail.
Unlawful non-citizens?
193 people in community detention.
Similarly, if they're an unlawful non-citizen, which they would be.
The then 246, but we now understand it's about 350 odd people impacted by NZYQ. Is that right?
Yes, bridging visa holders.
There were then 96 people on bridging visa Rs that predated NZYQ. That cohort still would have natural justice removed from them.
In relation to the giving of a removal pathway.
And then I think you also said that there are about 75,400 people without a valid visa. They would, that category still would have natural justice removed?
No, Senator, that would very much depend on their individual circumstances. So if you look at the definition of removal pathway non-citizen in Section 5 of the Act, for unlawful non-citizens, it's those who are liable for removal under Section 198 of the Act. For overstayers, the relevant removal provisions that would typically apply, they're in 198 subs 5 and 6. For those to apply, those people need to be in immigration detention. Those 76,500 odd, none of them are in immigration detention, so they would not be.
But if any of them were put into immigration detention, they would be a class that would also come under this.
Yes, but for people in that category, typically we would want to work with them to regularise their status, and detention would only be used as a last resort.
But they are in a category of where if a decision was made to put them in detention, if this bill passed, natural justice would not need to be accorded before they were given a direction.
No,
is that right?
But we would need to create a brief of evidence that was sufficiently strong to be able to convict the person and be mindful of the way that the criminal defence system works, and that I think to tell the full story you need to think about the framework that provision is already operating within.
Once they're being criminally prosecuted by the government.
Yeah.
So you're setting up the prosecution without requiring natural justice, and then separate to that, you're working out whether or not the prosecution would stick.
Well, we're designing a process that we think means that, for example, the person would be given a warning notice, have their rights explained to them, translated before we issued a notice, all with a view to making sure that should we get all the way through the process and they don't comply, we can have a prosecution that they can't say, of course I couldn't comply, I didn't understand, or you missed some key piece of information.
Well, you want to remove natural justice, for example, from somebody who fits in any of those categories we spoke about. Let's say it's a woman who has kids, they're concerned about domestic violence from the partner, the minister gives a direction for her to get a passport for the kids to help with the deportation. You want to remove natural justice in those circumstances. That's right, that's what the bill would do, remove natural justice from that direction. Correct?
So
that's the kind of direction a minister can give. You must get a passport.
I think our approach would almost certainly in that situation be to work with the family to understand why they're not taking steps to leave if they had no lawful right to remain.
That's if you gave them natural justice.
We would have been through, as we've been through with this committee, multiple rounds of understanding the family's circumstances, understanding they would have been through various review rights for their substantive visa to get to the position where they're an unlawful non-citizen on a removal pathway.
Let's say some delegated official gets to the position, wants to be able to have an order given, a direction given to the woman to get a passport. Now, she may at that point, or that the circumstances may only have just happened. The domestic violence may have only just happened. You may not be aware about the domestic violence. An order is given directing that woman to get a passport for her kids, and to do that, she has to go to the violent partner. And you want to be able to give that direction without ever asking her opinion or checking whether it's safe. That's what you want, isn't it? That's what this power would do.
Well, she would. Our process that we've designed, again, to ensure that it can withstand the proper defence that the Parliament has put into that provision, we need to ensure there's not a reasonable excuse for non-compliance with the direction.
Well, if you don't ask,
how
would you know?
We do issue a warning notice. We do engage. Our status resolution officers work very closely with people on a removal pathway.
You expressly want the power to give the order without asking. And I'll give you a very clear example where that would be potentially, because that woman in those circumstances would be fearing criminal prosecution. She's basically got a choice, because of the laws you're proposing, to either face the risk of domestic violence, confront a domestic partner, or go to jail. So that's the effect of these changes, isn't it?
So no one will be surprised if at any point the minister or a delegate issues a removal pathway direction. This is, and I think this was also our evidence when the Migration Amendment Bill was being considered by the committee late last year. This is the end of a process. These are people who, contrary to the expectations articulated by the Parliament through that Act, have not departed Australia when they have no right to remain. The department would have had multiple interactions with them along this throughout the course of seeking to resolve their status, and to work with them to affect their departure. There is nothing, of course, that precludes those individuals from raising any and all concerns that they may have with the department at any of those points of interaction. They essentially have a case officer. You just want to
remove the right, though.
That's what the bill proposes. This is in effect a direction.
Well, I'm assuming you're doing it for a purpose. Because if you're telling us, well, you already give everybody, you're going to be giving everybody natural justice regardless, it comes back to the question Senator Cash asks, why do you need the bill? And the reason you need the bill is because you want to be able to not give natural justice and not see a legal challenge. That's why you want the bill, isn't it?
Well, in the case of the removal pathway directions, it's so that we are following one set. We're going to run those cases through the criminal law system with the reasonable excuse defence, and not have an administrative law challenge running in parallel.
Criminalising a woman in the circumstances I told you, you want to take that straight to the criminal law, don't you?
Well, that is the scheme that was passed last year, Senator.
And so, for example, a migrant on an employer sponsorship who runs away from an abusive employer, you want to be able to, instead of giving natural justice in the immigration system, you want to be able to whack them on a removal pathway and deal with any niceties once you've decided to criminally prosecute them.
I think in that case, and we are getting very much into kind of hypotheticals and examples here, but there are multiple visa pathways that a person in those sorts of situations would apply for a visa, and they would have all of the procedural fairness rights we've been through. They would apply in those situations for a different visa type and go through the primary merits and judicial review processes.
Until you get to the point where you want to set them up for a criminal prosecution by giving them an order and a direction, which they may have very reasonable reasons for not complying with, but you don't want to hear about it because you want to be able to go down a criminal prosecution pathway.
Well, I guess I disagree with you. We do want to hear about that. We have designed a process that includes a warning notice letter, constant engagement with their case manager. This is a power that we would expect is used very infrequently, because once people start to understand this is the end of the road, the last step, people start to work on
jail some of these women, once you jail some of these employers, you think that would have an educative effect once you put a few of these people in jail. Is that the intention?
No, Senator.
Okay. Well, could I go back to the MOU? Now, I think you said there's no set number that are covered by the Nauru MOU. And I think you said it could be naught, but it could be 10,000 or 20,000 or 30,000 as well, couldn't it? I mean, that's the reality.
Senator, the MOU doesn't contain a cap or a number. The MOU establishes a framework for Australia to apply for visas and Nauru to consider granting them.
And what's the limitation from the purpose of the MOU? What's the limitation for the types of visas or the number of visas? Is it just up to the discretion of the two governments?
ultimately it is a matter of...
So when you say type of visas, Senator, so it's a long stay visa in Nauru. So
Well, no.
Is that so?
No,
is that
who from Australia can be covered by the MOU.
Right, not what's the visa that's being applied.
Yes.
My apologies.
Senator, the arrangement is designed for, and the policy intention underpinning it is to use it to provide a removal pathway for individuals who have no right to remain in Australia and who cannot be removed to their country of origin.
But I've asked for what's in the MOU. I might just simply check. Can you table the MOU?
I've indicated I'm going to share the call. I'm going to do that.
Can you table the MOU?
And we can come back to you on the next round. Senator Cash, you've got the call.
Thank you very much, Chair. I just want to close off...
Sorry, Senator Cash, I'll just interrupt you for a second. On the tabling of the ASRC document, the committee accepts. Yes, thank you. Sorry, Senator Cash.
No, that's okay. I just want to close off on some evidence so I don't need to come back to it and I can move on to other lines of questioning. If I could just go back to where I started, just in relation to the High Court. Could I just summarise the position on the court hearings and the need for urgency in this way? So, the government, if I recall the evidence, has applied for the removal of the TCXM matter to the High Court. Yep. Do you have a date on which that was done?
I'd have to take that on notice, Senator, but it was in the last few weeks. I just don't recall the specific
last few
date.
weeks, okay. Did you say something about a paperwork issue, to use your words?
Yes, that's right, Senator. That's what I said.
Can you just remind me what that was?
I didn't say what it was.
Oh,
before,
understood.
Senator.
So can I just confirm them? So we don't have a date, we haven't had a directions hearing, and we don't have a timetable.
Correct.
Okay. We also don't have certainty that the matter will be heard in the High Court. It still could be remitted back to the Federal Court, is that correct?
That's always a possibility, Senator. It's an application, as you know, by the Attorney-General to remove the matter involving a constitutional issue. That goes up as a right, but of course the High Court...
It doesn't have to, it can
remit
be.
it if it wishes, yes.
And so the principal argument for urgency is that the High Court, whenever it gets to this matter, may take into account the fact that there is a bill in the Parliament and may delay the listing of the matter on this basis.
Yes, Senator.
Okay, but in the meantime, there's nothing in the bill that prevents you from applying to Nauru visas now and taking people off the streets.
Correct, Senator.
Okay. So, I was a bit confused by the evidence before. So, we have a highly contingent argument about a hypothetical potential future delay in a court listening. And meanwhile, the one thing that everyone is focused on, or everyone here is focused on, and the passage of the bill does nothing one way or the other for the safety of the Australian community. These people, based on all the evidence, and we'll go back to it shortly, will remain in the street.
I don't think it's accurate to say the bill does nothing for the safety of the Australian community. What we consider the bill will do is make it easier to move people through this system through the Parliament has put in place last year, in terms of removing some of the grounds people are using to delay or frustrate their removal pursuant to the arrangement. So when this bill does pass, or if it were to pass, there are some common grounds being argued that will not be available. So you'd know from your time in government, no doubt other arguments will crop up, but we are removing some of the most common grounds.
But the bill itself doesn't take people off the streets, is what I'm saying.
Well, no, the bill does not authorise the detention of anyone.
Thank you. That's all I needed to get to. Can I now just go back to exploring the Memorandum of Understanding? Is that a public document?
No, not currently.
Not currently, right. Can you table it then or not?
I think we would need to take that on notice. I understand an order for the production of it was issued.
I think it's just been, I think in our absence, Magala, I hope the Senate has just passed an order for production.
Right,
Might depend on your cooperation on that.
I don't know, but if that is true, that would be good to get that before, as part of the notice, questions on notice tomorrow. Now, the figures just so I've got them right in my mind. There is a trust that is going to be set up. There's $408 million as part of the deal as the lump sum. $388 million is going into a trust that is going to be administered jointly by the Government of Australia and the Government of Nauru. Are there any conditions around the drawing down of the trust yet?
So the terms of the trust are still being negotiated, but the key terms that are critical is, if you imagine the funds associated with the trust, there's the principal and then there'll be the annual interest.
Yep.
The annual interest will be available to Nauru each year. The principal will be held in the trust and can't be accessed for the duration of the trust, which will be 30 years.
Okay. Can I just ask, when you say the interest will be available, is that dependent on how many they take?
No, but the terms we're negotiating include a clawback provision that enable the trust to be dissolved and the funds returned to Australia in the event that the purpose of the head MOU isn't being achieved.
Okay. So in terms, the 20 million up front they're going to get, when do you have to pay the 20 million? So that, just say the bill passes tomorrow and eventually it receives royal assent very quickly. When does the 20 million get handed over?
After the arrival of the first person under the agreement.
Right, so the first person...
Just to get the record, because I've just been told that the order for the production of the MOU was negatived, and I think the Coalition and Labor voted together to not produce it.
Well, now I'm still asking for it to be tabled, so there you go.
Yes.
In a separate committee hearing. There might have been a different reason for the vote in the Senate, I don't know, but it would be good if we could get it tabled. The document exists, correct?
Yeah, it was signed.
It was signed, yes. So there's a document in existence. So the 20 million...
But just as I'm explaining, some of the subsidiary documents, including the trust deed that we're talking about, has not been signed yet and is not...
Understood. With the 20 million, you referred previously to the upfront costs. How do they start preparation for taking someone if they don't have access to money, if the 20 million's only being paid when the first person arrives?
Do you want to answer that, Mr Whittington?
Senator, the 20 million allows for broad start-up costs for the Government of Nauru. Many aspects that the Government of Nauru may wish to put in place in response to their grant of visas to long-term visa holders and their understanding of those people, their particular antecedents and what they would need to do within their own community to provide for the welfare, the accommodation, the medical supports for those people within the community. And then over time, as greater numbers of people would be granted visas and transferred to Nauru, the payment arrangements allow for greater payment to Nauru to manage those services.
Sorry, but the 20 million, I just need to understand, is it when the first visa holder puts their feet on Nauruan soil?
That's correct.
So up until then, they can't do any preparatory work or anything like that, or if they do, they're incurring the expense themselves.
That's right, although you'd be familiar, Australia has provided substantial financial assistance to Nauru over some time. So, for example, and I think we traversed this in a previous estimates hearing, accommodation is ready and available. A couple of years ago, Australia gifted Nauru particular accommodation. Those abodes have been made ready. So the Nauru aren't concerned that they don't have the facilities to accommodate the first few, and they're comfortable with that arrangement.
You also mentioned a figure of $70 million. What was that figure?
That figure will be paid from year 2 onwards.
And every year? For how long?
For the duration of the MOU.
Well, hold on. The MOU didn't have...
Sorry, well, it's a 30-year...
So they get $70 million per year for 30 years?
in the order of 70 million, but money will be split between the trust fund and payments direct to Nauru based on the number of people actually with visas on Nauru.
So hold on. So the deal that was announced, I just need to get this right, was 408 million. Part of that 408 is the 20 million up front, but also as part of the deal, there's 70 million per year commencing in year 2 that gets paid for as long as the agreement's going, which is 30 years. So how long is the agreement for?
It's for 30 years.
Yeah, so 3 7s are 21. What is the total amount of money that Nauru could get under this deal?
I don't have that figure.
Is it $2 billion over the life of the agreement?
No, it's 2.6.
$2.6 billion over the life of the agreement.
$2.5 billion.
Yeah, $70 million.
$2.5 billion.
At approximately 30 years. What happens? Can the government say, well, we've sent you 6 people, you won't take any more, so we're stopping the 70 million?
Correct, yes.
Each year?
Yes.
Right. What opportunity does Nauru have to give us these people back?
Senator, the individuals will have no visa for Australia.
Right, okay. So it's a serious decision for Nauru. You also said earlier, just going back in terms of just trying to wrap up everything on the costs, there is a cost for each visa application to be paid by Australia. How much is that cost anticipated to be?
The Nauruan regulations provide for that. Mr Biddington might be able to assist.
Yes, thanks, Senator. The Nauruan regulation provides for the visa fee, and the visa fee is set at $1,000 a year for the visa.
Right. Is there any other cost associated with that person in terms of the visa application? Is there any other cost associated with them?
The financial arrangement for that annual payment is still being finalised with Nauru. So that's
the $70 million annual payment.
That's it. That's why I've been careful, I think, a few times to say around 70 million.
Yep.
We expect that will capture the costs, but as I said, we are still finalising discussions.
Okay. The visa fee, is that paid separately, or does that get drawn down from the trust, the 408 million? Minus the 20, the 388 sitting in the trust.
That sum will be paid as the department applies for visas.
Oh, so it's in addition to the money. So at this point in time, we've got 408 million was announced, 388 goes into trust, $1,000 approximately per person as a fee, and then as of year 2, $70 million or thereabouts for the term of the agreement, which is 30 years.
Which some of which goes into trust as well, depending on the number of people on Nauru. So if they were in the scenario you posed a little while ago, if there's 6 people on Nauru, the majority of that payment goes into trust and sits in the trust, and should the agreement be frustrated and it never grows and never delivers, the trust could be clawed back.
Just in terms of the visa application, that's totally separate from the 70 million, the 408 million, totally separate.
Yes.
That's okay. Just in terms of the drawdown and how the remaining 388 million is handled, which will obviously be a growing amount, you've said that the interest is paid to Nauru. Is the principal at all distributed to Nauru?
Not for the life of the 30 years.
What happens at the end of the 30 years?
Nauru would realise the value of the trust.
Right, they would realise the value of the trust. So there could be, well, effectively, yes. So how many of the cohort would they need to get the full amount of around 2.5 billion over 30 years?
Senator, those terms aren't settled yet.
Well, this is the problem then, if they're not settled, because are you saying that Nauru could say, we're happy to take 5 and we still want the 70 million a year? That's part of a negotiation for 30 years.
Well, the terms of the clawback that is currently on the table would say that Australia could terminate the trust in those circumstances.
And then Nauru could say, well, thanks so much, we're not interested then in taking anybody. We've already got the option on the table to take 0, but if you don't agree to our terms, quite frankly, we're not interested.
Well, Senator,
It's a negotiation.
that's
So
right.
in the 30 years' time, Nauru stands to get something in the order, if it all goes to plan, of $2.5 billion, because we don't know how many people that is actually contingent on. But in the meantime, they get the interest from an ever-growing trust. Is that correct?
Senator, the key component here would be the ability to terminate the trust where it's practically ineffective in achieving its purpose. So if that is the outcome, and if that number were any number that became ineffective in achieving the purpose, then the trust could be terminated on that basis.
I'll come back and explore this further.
And the only way you would ever get that much money accumulating in the trust is that no people or very few people were actually removed to Nauru, in which case the triggers to terminate and claw back the entirety of the principal would be available for Australia.
Realistically, no, you won't be doing the clawback, but that's my opinion.
Senator Pocock.
Thank you for your time this evening. Just wanted to pick up where Senator Cash left off. Is there an assumption around the interest rate over that 30-year period that you've built into this?
Senator, those details are being worked through for the...
Still working through?
Yes, correct.
Is there a minimum interest rate that is being inserted into it?
Again, Senator, those documents are still being worked through.
So it wasn't in the headline document we've heard has been signed?
No, the MOU sets up the framework for Australia to apply for visas and Nauru to consider whether to grant. Then the MOU provides that the governments may enter into subsidiary financial agreements, and the trust arrangement will be a subsidiary financial agreement to the head MOU.
Okay. And so, I guess this is probably hypothetical, but I take from that there could actually be a minimum interest rate in the agreement, which would mean that if interest rates went below that, we would effectively have to top up the payment to Nauru. There could be sort of a floor.
There's no term like that under discussion.
There's no term like that? Okay. Great. Have you got an idea of Senator Cash was asking about the total, the entirety of this agreement with the 20 mil, the 70 mil, and then actually giving them the $388 million principal at the end?
I don't have that figure with me.
No one's worked it out?
It's approximately 2.5 billion. Yes.
Okay. So Senator Shoebridge is spot on there.
But yeah, as I said, noting that
Sure.
That allocation between the trust fund and noting the effect of the clawback mechanism mean that it's pretty speculative to say it will definitely be worth that much money to Nauru at this point in time.
And is there a maximum number on the number of people that Nauru will take? Has that been?
That is not in the MOU.
On the MOU. Okay, thank you. Did the department consult civil society on the bill before its introduction to the Parliament?
Consult with who?
Civil society?
No, Senator.
No. Why not?
One of the primary purposes of the bill is to address some arguments that are currently being run in various court matters, and it wouldn't have assisted, I don't think, our legal position to have publicly consulted on those prior to introducing the bill.
And the statement of compatibility with human rights on page 26 states that while procedural fairness is excluded from processes relating to third country reception arrangements, the department would nevertheless ensure that any information relating to potential refoulement concerns with respect to the third country would be assessed before removal occurs. How will the department properly make this assessment without the opportunity for the individual to put their case regarding the harm they may face if removed to the third country, including to share new information about the removal that may have not been known or apparent or relevant earlier in the process?
Would you like to answer that, Mr. Burke?
Well, so I think it kind of goes to what's already in the Migration Act, in that where there has been a protection finding, then a removal pathway direction can't be made in respect to the country where that finding has been made. If it's an individual who has to date been non-cooperative with their removal, and we had this discussion a little before, Senator, the issuing of a direction comes at the end of an extended process of engagement with the individual. The individual would have numerous opportunities to raise those concerns, and as a fairly standard practice, I would say, for the department in undertaking a removal, there is always a thought given to any risk of refoulement that may occur with that particular removal. So those frameworks are already in place.
And they're applied prior to any removal. We work our way through a pre-removal clearance process that checks that the person, based on the information known to the department, is not being exposed to a refoulement problem by being removed to the country that we're proposing to remove them to. That's regardless of third country reception. That's every removal we do.
But do they have an opportunity to provide you with more information, or say, well, actually, you've missed this, or
well,
it's just
no, they don't. Not
Why
for
not?
that process, because typically people have had the opportunity to claim protection. They've been in Australia for many years. They've been through multiple processes. Many people do say put in information when they know they're issued with a notice of intention to remove. They can at that point say you can't remove it, and that notice will tell them where to. They get notice. They can absolutely say at that point and make a claim, or say you can't move me there. And outline some characteristic that means that they think they'll be persecuted on the basis of that characteristic, and we would look at that and take it into account in the pre-removal clearance process.
But if you decided that, well, sure, but we still want to send you, there's nothing they can do.
That would be a very significant decision. That's got nothing to
This is
do
a
with
very
procedural.
significant bill, so.
Well, but what you're talking about there is us identifying there's a refoulement problem and removing someone anyway. That the bill doesn't go anywhere near that kind of consideration. The bill doesn't allow us, it doesn't change the removal powers, it doesn't change who's liable for removal, and it certainly doesn't change the way the protection finding works.
Okay. Are the Safe Hands Group or Black Dog Group services still engaged to provide security services on Nauru with Australian taxpayer money?
I don't have that information, Mr. Biddington.
No, I don't have that information either.
Maybe just on notice.
But it would...
on notice, and just the value of those contracts. My understanding is that was reported in the 9 newspapers on the 6th of August this year. I'm just wondering if there's been any due diligence or investigation off the back of those allegations, given that those two companies are controlled by Fink's bikie gang leader, Ali Bilal.
So, Senator, those contracts which were the subject of the news reporting are unrelated to regional processing. They're not contracts with the Australian government, and it would be a matter for the government of Nauru in relation to those particular contracts.
But we're providing money to them. There's no need for due diligence there? Or we just hand money over and kind of...
They are a sovereign government.
No, I understand that, but it's our taxpayer money.
The contract they entered into before an MOU, weeks before an MOU with the Australian government for services that are unrelated to anything we have transferred to them at this point in time, isn't something that we had an oversight right in relation to.
Thank you. And Just in terms of this agreement, is there anything stopping Nauru then sending people on to somewhere else? Do they have to keep them there for 30 years?
No, people will have a long-term entry visa and the person can by choice enter and exit Nauru. They've got travel rights. So they're certainly not locked on Nauru, if that was... there is a requirement that Nauru are signatories to the Refugees Convention, and there is a requirement that Nauru don't chain refool them, as in send them back to somewhere to whom they own protection from.
But they can't come to Australia.
No, they wouldn't have any right of entry to Australia,
Yeah,
Senator.
and they can't apply to a visa for Australia.
Would that be Barb?
It'd depend on their individual circumstances.
Oh, okay.
But
This is Senator Pocock.
that said, given...
It's Senator Pocock's time.
It's a good question.
Yeah.
And what happens at the end of 30 years for these people?
That will be a matter for us to work through with Nauru. The visas are a minimum of 30 years.
Yeah. You mentioned that Nauru are a signatory to the Refugee Convention. I assume Australia is too.
Yes.
Is this compatible with the Refugee Convention?
Yes, we consider it is.
Okay. Okay, I'm happy to pass the call there. Thanks, Chair.
Thank you. I'm going to go to Senator Shoebridge, and I'm going to move in 10-minute blocks because we're getting crunched for time. Senator Shoebridge.
Thanks, Chair. So I'm going to again ask you, can you please table the MOU?
Senator, I need to take that on notice and discuss with the Minister.
All right. Well, I think the questions will have to be provided on notice, I think, by 10 a.m. tomorrow morning. So, okay, that's likely. All right. Well, I'd ask you to, to table it in accordance with that obligation, if it's passed. Does the MOU contain an obligation on Nauru not to engage in chain refoulement? Is it in the MOU?
Yes, Senator.
What is the provision in the MOU?
Senator, the MOU goes to broad principles as to the proper conduct by Government of Nauru, and requires that people who hold long-term stay visas are treated in accordance with international legal obligations. They have freedom of movement, not subject to arbitrary detention, and that they and that they have the right to raise protection claims.
So it says international legal obligations. Does it reference the Refugee Convention?
Sorry to jump in, Senator, but if you look at Schedule 3 of the Nauruan regulation for the visa, it deals with that quite explicitly. It says the holder of a visa shall not be removed from the Republic where there is a risk of deprivation of life, death penalty, cruel, inhumane or degrading treatment, punishment or persecution, chain refoulement, being imposed with punitive conditions in support of community safety, so on. So it's Nauruan law that the individual cannot be chain reformed.
Well, given Nauru is a sovereign government and can change its law tomorrow if it chooses, you agree with that?
I do
yes,
agree.
although the MOU does also contain provisions that would require Nauru to consult with us on any proposed change to that particular regulation.
All right, requires consultation. Does it prohibit Nauru from removing the protection against chain refoulement? Does the MOU do that?
No, but the way the payment mechanisms are structured, there is a strong incentive for Nauru to maintain an arrangement that would allow Australia to comply with its international law obligations.
Does the MOU reference explicitly the Refugee Convention?
We'll need to take that on notice.
Well, I think Mr Biddington, you indicated earlier it didn't. Is that position going to change now?
Point of order, Chair. I think that Ms Sharp had taken that question on notice.
But Mr Biddington had already answered
asking
it.
another witness the same question or verballing them should not be allowed.
That's not a point of order.
It is a point of order.
With all due respect, this is a hearing, so we can inquire into the bill. The Senate did agree to it. it would just be easy to facilitate if a witness can answer the question, if they could just answer it, because otherwise there's just going to be more work for the department tonight.
Thank you.
And
It just,
Officials, if
thank you, Chair.
respectfully,
He doesn't have it in front of him. It would be cleaner for us just to take it on notice.
Thank you.
Well, I mean, the test isn't cleaner. The test is if a witness has knowledge, and you would have read the provisions about preparation for these hearings. If you have the knowledge, the test isn't cleaner or not cleaner. Mr Biddington, I'm just going to ask, is it in your knowledge whether or not the MOU references the Refugee Convention?
Senator, I've certainly read the document in preparation for these proceedings, but I cannot recall precisely if that is mentioned in the terms. The document is lengthy, and with the discussion that's gone on, I think it would be appropriate to check and take it on notice.
All right. Well, I mean,
I think that's fair enough.
given the Nauru president has said expressly in relation to the arrangements that have been entered into with Australia and the immediate preceding arrangements, the long-term goal remains the eventual repatriation of these individuals to their home countries. Has anyone from the Australian government sought clarification of whether the President of Nauru maintains that position or not?
Senator, I recall our exchange at Senator Smith's earlier this year about those comments, which were in Nauruan language.
Which I've now had checked, and that's what he says. But have you checked? Like you've had 9 months?
We have not received an official translation of those comments, but in any event, we take confidence not from a comment made in media commentary to the Nauruan population in Nauruan. We look at the laws of Nauru and those regulations which say on their face there will be no chain refoulement, as well as ensuring the structure of the agreement incentivises Nauru to comply with its international obligations.
So you're not giving weight to the statement from the Nauruan president because it was made in Nauruan?
No, I'm not giving weight relative to the regulations of the Government of Nauru, backed up by a payment structure that will incentivise Nauru to act in accordance with international obligations.
And to be absolutely clear, nobody in the Australian government, to the best of your knowledge, has clarified the terms of the President of Nauru's statement, despite the widespread reporting that he had said the long-term goal remains the eventual repatriation of these individuals to their home countries. No one's checked if that was true or not.
I would need to take on notice a statement like no one in the Australian government has checked. I absolutely could not speak with confidence.
Well, has anyone in the department, to the best of your knowledge, made such a check?
I'm not aware of it, but I will check.
Anybody? I'm happy. Does anybody know? Has anyone checked? I mean, it's pretty important because this is chain refoulement.
I think Ms Sharp has taken question on notice.
Well, you know, it's just a gross breach of the Refugee Convention, but no one checked. Is that the situation?
No, Senator, we've negotiated an MOU. Okay. We have got arrangements in place to ensure that these regulations aren't changed without consultation with the Australian government. We have designed a framework that gives us confidence that Australia will be able to uphold its international law obligations.
Is there anything in the MOU preventing the money going to the Finks motorcycle gang, given that's who Nauru has currently entered into a $40 million contract with? So is there anything in the MOU that says Nauru can't give the money to the Finks motorcycle gang?
The MOU sets up the framework for applying for visas and Nauru to grant visas. The parties can enter into subsidiary financial agreements, which is what we're negotiating now, and those. So the MOU itself doesn't contain the money.
Okay. So nothing in there that says you can't keep using Australian taxpayers' money to fund the Finks motorcycle gang.
But I'd add, Senator, that in terms of the clawback provisions which were being discussed before, one of those provisions is for gross failure in distribution of funds not being applied for a TCRA purpose. And so if that was the case, then the Australian government could use that provision to exit from the MOU.
There are multiple provisions in this bill for retrospectivity. How many legal cases are you aware of that those retrospective provisions would apply to? How many cases that are currently on foot?
I think we need to take the different powers that the procedural fairness provisions apply to.
Let's go through the multiple retrospectivity provisions.
Would you like to want to share the call?
Flagging the rules out in the chat about timing of the time frame for hearings. Outside of this.
Sorry, Senator, was there any particular measure you'd like me to start with?
Well, I mean...
Or shall we just go through in...
It's not a long bill. Why don't we just go through each
sure.
of the retrospective provisions?
Yeah. So with the retrospective provisions in relation to the third country reception arrangements, the answer is 0 because the federal court has found that procedural fairness does not attach, or did not attach rather, to the entering into of the interim third country reception arrangement.
Is that the subject of an appeal?
It is, yes.
And are there other cases asserting a natural justice obligation?
Yes.
So obviously it would apply to those cases because it would...
That would depend on the outcome of the appeal, Senator.
Well, I mean,
I'm just saying what the law as currently stated by the federal court.
But a first instance judgment is not binding, so that wouldn't...
It is binding, Senator.
Well, in the one instance, but it doesn't bind other judges.
Senator,
So how many of those cases are there?
Last question.
There are 3.
All right. And do you have, just so as we can deal with the retrospectivity, do you mind just if we just go through the other retrospective provisions? The part 2?
So part 2 deals with visa decisions made by decision makers prior to the judgment in NZYQ on the 8th of November 2023 and made on the basis of the law as it then stood, as outlined by the High Court in the Al-Kateb case.
But which was found to be wrong in NZYQ.
Indeed.
So how many cases is that?
I'm coming to that, Senator.
So if you could make your answer swift, because I need to rotate the call and we're running out of time.
Thanks, Chair. There's no, we don't have a precise number because it is incredibly fact dependent in an individual case. The question about whether a jurisdictional error will arise on that basis, whether that error is material, is incredibly fact dependent. There are several cases already in the federal court jurisprudence that have gone each way on that question on the particular facts of the case. So it'd be really impossible for us to be able to conclusively indicate, all of the potential cases where the argument could be run, which way it would go.
Well, just for the moment, it's how many current cases you're aware of.
I'm going to share the call and I'm going to go to Senator Pocock and then to Senator Cash.
Thank you. Ms Sharp, the Richardson Review to investigate integrity concerns in procurement and management of taxpayer funds in offshore processing, does this sort of align with and comply with the recommendations of that review?
Well, as I've said, the final financial arrangement hasn't been settled yet. The head MOU and the structure of the payment mechanism and the trust, with most of the money sitting in trust and subject to a clawback mechanism, with the ability for Australia to claw the money back, gives us a very powerful way of influencing behaviour, including contracting behaviour. Noting that Nauru is a sovereign country and should probably have the ability to contract who it likes, but with some...
So this is not a procurement. The Australian government is not entering into a procurement. It's a bilateral agreement with another sovereign state. The Australian government will not be a party to nor participate in any contracting arrangements the government of Nauru may or may not enter into. So we are not contracting.
Okay. So the Richardson Review sort of doesn't really apply to this then? Is that what you're saying?
The Richardson review was focused on our contracting relationships and the subcontracts that were entered into. As Mr. Burke has outlined, this isn't a procurement as such, but of course we're mindful of the operating environment, the lessons learnt over years in the delivery of services on Nauru.
Well, I'm concerned that you're not mindful enough, because we've had allegations that taxpayer money is going to bikie gangs who are providing security on Nauru, and we haven't even, there's an acknowledgement that you're actually looking into it. So, anyway, I'll leave that as a statement. Sorry. You mentioned this is sort of an agreement with Nauru. We've seen in the past concern about Nauru doing a deal with China. Does this agreement contain anything beyond just a 30-year, $2.5 billion payment to take people? Is there anything to do with security that they won't do another deal with another foreign country, as we've seen happen in the Pacific?
Senator, this arrangement is about, it is a third country reception arrangement pursuant to the Migration Act.
Yes.
It isn't about other matters.
And so you can confirm that there is no other condition of this agreement when it comes to Nauru?
I would want to carefully review the MOU and take that on notice. Any other condition is quite a broad.
Mm-hmm. Sure. If you can take it on notice, any other conditions, and particularly anything to do with an assurance around security or an agreement not to enter into agreements around policing or anything else with another foreign country. And just to come back to Senator Cash's questioning about the interest, and forgive the sort of layman's terms, but this money is just going to be put into like a high interest account, or it's going to be actively invested in, say, the future fund, or which one is it?
It will be actively invested.
Right.
It will be a jointly managed trust. It's a model that Nauru has operating in another context, and is helping to support Nauru's long-term economic resilience.
And so on that then, if it is actively managed, if you look at the returns of the average super fund in Australia, we're looking at around 10%. And so that, in mine, is about $7.7 billion over 30 years.
So Nauru
You said 2.5.
I think the question, sorry, Senator, if I've confused, I wasn't thinking about the value of all their interest earnings over that period of time.
So if it is actively managed and we get the long-term average on returns, we are potentially looking at around $7.5 billion.
I think that depends on what's in the trust, and as Ms Sharp has outlined there.
Well, was it $388 million?
You're just talking the base amount.
I think you're asking us to comment on calculations we have not done.
No, I'm asking you to. So we now know it's actively invested. It's not just sitting in a high interest account at one of the banks. That's going to provide a much, based on historic earnings, that's going to provide a much bigger sum than $2.5 billion.
Well, I think it's important to understand managing this cohort on Nauru will cost money over those 30 years, and we expect Nauru to spend money to ensure that the people are effectively supported, cared for, healthcare is provided. Yes. It is not the case that every dollar of it can be poured back into the fund and no money be spent over 30 years.
I understand that, but I just want you to confirm that this would actually be, based on historic data, more around $7.5 billion.
I can't confirm that.
You've done no modelling?
Certainly not on an assumption that it sounds like you're making, that everything is getting poured back in and no money is being spent to support the third country reception arrangement. That would not meet the terms of what we need Nauru to provide, which is services, healthcare, housing, those things.
And you think if it's returning 10% a year, that'll require more than the 38 million a year? You expect them to be drawing down more than 38 million a year for that?
So,
like, how expensive is it to look after? Like, how many people are we talking?
it's the cost.
I just want you to know, like, to people out there, this sounds totally bonkers, right? Like nuts. This is an extraordinary amount of money. We all know it's expensive to house people, but $2.5 to $7.7 billion over 30 years, like that's.
I absolutely can't comment on your assertion that there's $7.5 billion. I can't. We have no modelling that would indicate that figure is available.
The $2.5 billion was based on what sort of return? Like, how did you get to that figure?
That figure is simply the amounts Australia is providing to Nauru.
Australia's contribution.
And so anything. Thanks, Senator Cox. Anything above that is actually earned is additional to the 2.5, which you'd assume there'll be quite a bit.
Well, it's the investment trust hasn't been set, the investment strategy hasn't been set, and I think it would be irresponsible for me to offer a comment on a figure like $7.5 billion when I have no figures or any briefing that would indicate those figures are real.
I'm just fascinated that we're sitting here, we're meant to be voting on a bill tomorrow, and I would have thought that the department would have had a good look at this and gone, okay, well, these are some of the assumptions, like this, surely the stuff isn't that hard. These are some of the assumptions about drawdown, these are some of the assumptions about the long-term 30-year return, and that's what we think will end up being in this big bucket of money when we hand it over. That work hasn't been done?
So this bill doesn't create the power to enter into the third country reception arrangement. That already exists in the Act. This bill is just about the natural justice provisions for actions undertaken in respect of a third country.
Yes, which enables all the other stuff.
So I guess I'm just pointing out the link between the passage of this bill and the MOU that's been signed. That it's not there.
Sure, but you've got an MOU
that was signed was based on the amendments that were made to the Migration Act.
We have an MOU that provides for subsidiary financial arrangements to be entered into. We're negotiating the subsidiary financial arrangements, including the terms of the trust. We do not have a complete economic model for the final value. We've been as upfront as we can be about how much money Australian taxpayers are contributing.
What's the time frame for that? What's the time frame for finalising that?
Well, we will be doing it as efficiently as we can. We need to be in a position so that the first time when we're ready for the first person to arrive on Nauru, we're also ready for the money to be payable.
Is there a plan for the first, assuming that it passes tomorrow, is there a plan for the first person to leave Australia?
As we outlined to Senator Cash earlier, the passage of the bill is not linked to... We have the power to apply for visas now.
Yeah, but they're not going to take them until this bill passes.
There's nothing in the bill... Sorry, you go.
No, the same point. If this bill doesn't pass, we will continue with the implementation of the MOU. We will do so on our understanding of current law, which Mr. Frank has spoken about. When the first individual arrives on Nauru, we will make the payments under the financial arrangements that Mr. Biddington has talked about that are currently being finalised. If this bill doesn't pass, we will seek to implement the TCRA as has been agreed to between the two governments.
Senator Pocock, I'm just seeking to understand how much longer...
Just last one.
Last one? Okay, thank you.
I guess, my frustration here is that either you're not telling us, giving us the information, or you haven't... I'd assume, like, Home Affairs would be doing all this stuff, have done some modelling, have worked out, okay, well, this is actually our plan. We think we can send the first person on this date, all those sorts of things. Like, is that not stuff you guys do?
We absolutely do operational planning. The variables in this arrangement to give you a precise date is difficult for us.
I don't want a precise date. Just what is the...
We'll be looking to commence the process of applying for visas in the coming weeks. But the variables that will influence when somebody actually arrives on Nauru include whether they seek to file some sort of action trying to prevent the removal, whether the court injuncts the removal, how long the court takes to list it, and I guess even precursor to that, how long Nauru takes to consider whether to issue the visa. So there's a bunch of factors outside of our control, which is why we're loath to tell you it's this date.
Thank you, Senator Pocock.
Thank you.
Appreciate it. I also want to inform Department that the committee's agreed to go for another hour with handing the call to Senator Cash.
Thank you. Over 30 minutes. I'll be as concise as I can in my line of questioning. I'm going to summarise one or two issues. I'm then going to move to 3 blocks of questions in relation to discussions that have had as to why the Coalition does need to support the bill between the relevant shadow and the Minister in the other place. So, can I just close off on costs? How many people does Nauru need to take to obtain the full amount, somewhere in excess of $2.5 billion over the 30 years plus interest, given that they are not under any obligation to accept anyone?
That detail will be in the financial agreement that hasn't been settled yet.
Okay. Can I now just go to the evidence that was given to Senator Pocock? The bill is just about natural justice.
That's correct.
Okay, so it's not about community safety or removing people from the streets. It is about the natural justice aspect.
The natural justice aspect, and I guess the reason for the bill, Senator, is part of the process of, I guess, the lifetime journey. What we're trying to do here is clarify that when people have come to the end of that journey around the removals process, that natural justice isn't part of that process.
Okay. So, just very quickly, I do not need to go to the murder of the Melbourne man by the immigration detainee, as it's been given to us as a reason to why we have to pass this bill. On the 15th of June, a 62-year-old man was allegedly viciously assaulted in Melbourne by Mr Friday Okoju, an immigration detainee freed by the government. The victim died from his injuries in the hospital, and the perpetrator has since been charged with murder. Can I confirm there is nothing in the provisions of this bill which would have prevented that outcome? Is that correct?
No, Senator. Oh, sorry. The bill deals with procedural fairness that will enable people who are subject to a third country removal arrangement to potentially be moved more quickly.
Thank you.
From immigration detention to removal.
Is it fair to say that broadly the way you could have prevented that outcome, so the murder unfortunately, would be if there was a community safety detention order in place, or if you'd made some other arrangement with Nauru or another country that could return the offender to immigration detention?
Senator, I'm not sure if that's a hypothetical. You're asking us to comment on
what
this could have prevented one person from murdering another.
No.
It's a very difficult set of facts.
I need to phrase it better. No, to be fair. Okay, so I need to raise this case because it has been put to the opposition that this murder is one of the reasons we are passing the bill urgently. Okay? So I need to understand, the bill itself deals, as we've understood, with natural justice. I just now need to understand, if there had been a community safety detention order in place, what would that have been? What effect would that have had on Mr Friday Okoju?
If a person is subject to a detention order, they would be detained.
Thank you very much. Okay. He wasn't subject to a detention order, was he? A preventative detention order?
No, Senator.
What was reported about that crime was obviously horrific. He was subject to electronic monitoring under strict conditions, but when Australian Border Force officers intervened, he was stomping on an innocent man's head. Is that correct?
Senator, I'm being cautious here. We don't comment on individual cases, individual facts. And
I'm only merely asking for the circumstances in which the Australian Border Force officers intervened and what they witnessed, which was, I understand, the stomping on the innocent man's head.
And that matter will go before the courts in a criminal prosecution. So I want to take on notice any commentary about the facts of that incident to avoid prejudicing
Why wasn't he subject to a preventative detention order?
Senator, you're again asking for us to comment on a particular individual's case and facts, which I would need to take on notice.
Can you advise how many times this man had been charged with offences since being released from detention, including any charges that had fallen over?
I'm going to take that on notice too, Senator.
Was he on bail at the time of the alleged assault?
I'd need to take that on notice. I don't have any information about that case with me.
No, that's not. And the reason, as I said though, the reason I need to ask these questions and press them is it's been put to us, I understand, that this murder is one of the reasons for passing the bill urgently. So we've got to provide. I'm going to ask you. I will put a whole lot of questions on notice to get the answers overnight. How many then preventative detention orders have actually been imposed overall?
There have been no preventative detention orders imposed.
Right. Okay. No preventative detention orders imposed. Okay. Why not?
Senator, we've given extensive evidence over a series of Senate estimates hearings about this. In short, the short answer is the threshold that we are required to meet in order to apply for a community safety detention order is very high.
That actually leads me perfectly into my next question, actually. So in an interview with Andrew Clennell on the 29th of June 2025, Minister Burke said no one has come close to reaching the threshold that is the legislation. So that is still the case?
That is still the case.
Okay. How many times has the department met with the Minister regarding possible applications under the preventative detention order regime?
For clarity, the regime is the community safety order scheme, and it provides for two types of order: community safety detention orders and community safety supervision orders.
Yes.
And when we look at a case, we look at the full spectrum. The law requires us to do that. Yep. So I know you're zeroing in on detention,
no, that's fine. Yep, understood.
I wouldn't zero in on it like that.
Yep.
And I would need to take on notice. I definitely do not have a list of every meeting I've had with the Minister with me.
But have there been some meetings?
There have been multiple meetings and discussions. And
in particular in relation to, I do need to hone in the preventative detention regime orders?
There have been multiple meetings with the Minister.
Okay. Has the government contemplated legislative changes to lower the threshold to make it easier to apply for a community safety order?
Senator, we have had a goal of community safety since the NZYQ decision. As you're familiar with, there's been multiple bills taken through the Parliament looking at which are the most effective and practical ways of securing community safety. The community safety order scheme is one way, but as was the Commonwealth's experience also in the high-risk terrorism offender scheme, it's a pretty unwieldy framework to deal with. So we're looking at a range of things constantly to try and improve the system as a whole.
So just go back to my question then. Has the government contemplated legislative changes to lower the threshold, given the evidence in particular, or given the statements by Minister Burke, that no one has come close to reaching the threshold that is the legislation? And given, we have to be honest here, there have been some devastating incidents as a result of people not being in detention in my home state in Western Australia, but unfortunately more recently the murder of this gentleman.
I agree with you. It is devastating and a really difficult thing for us to manage this scheme. We have parameters that are pretty closely scrutinised by the court. Every set of rules we put in place are challenged in the courts. So going to your question, I'll need to take on notice the precision of your question. Have we considered legislative amendments to that scheme? But we are constantly looking at where will the law allow us to strengthen it. Our focus at the moment is on third country reception arrangement as a way of tackling the community safety question.
Did you see the problem, though, in terms of we were told that one of the reasons for passing the bill urgently is due to a vicious murder. But as we've heard, this bill does nothing, from the evidence that I've been given, this bill does nothing to actually address, for want of better words, the murder that occurred. The mechanism that potentially could have been used, which is a preventative detention order, wasn't used because the threshold is too high. And the problem we now face in terms of looking at this bill tonight and then considering our position tomorrow, the threshold isn't addressed by this bill. Do you see what I mean? So you've got a bill that deals with procedural fairness, but also there was an opportunity potentially to put in the lowering of the threshold.
The threshold that is in the Community Safety Order Scheme is modelled on the threshold that is in the High Risk Terrorism Offenders Scheme. And the reason it was modelled on that was that the High Court has held that that set of thresholds is constitutionally valid.
But there's nothing in this bill then that would have prevented that murder in terms of an amendment to lower the threshold?
I'm not sure any legislative amendment on its own can prevent a murder.
Well, the person being behind bars. But
yeah, if it was a constitutionally valid law,
the person being
Senator.
in detention would have meant they weren't on the streets and they weren't given the ability. The problem that I have is this, now that we've had the opportunity to explore it in the short time that we've had, the government is using a piecemeal approach, and my worry is why haven't we taken the time to actually get this right rather than rushing it through when lowering the threshold would seem to be something that we should have been looking at?
I think you're asking me to comment on kind of government policy and the approach. Minister Burke's been very clear that his first and best option is removal of this cohort from Australia. That's what this bill is seeking to make more effective.
So could I just ask there, would it be possible to lower the threshold? And if so, how would you go about doing that?
I would need to take that on notice. I think you're asking for something that is a pretty detailed legal question about the scheme has been designed to fit within parameters that have been approved by the High Court. Lowering the threshold would require pretty detailed advice.
So I'm just trying to work through, in the time that I have now, what questions I need to get through. So, the bill doesn't lower the threshold. We're talking about a bill that deals with the procedural fairness issue. What happens if Nauru takes 0 people? Then we're still at square one in terms of you have people in the community. You're saying, and Mr Burke has said, the threshold to date, no one has come close to reaching the threshold in that legislation. So you may end up actually still needing to lower the threshold if none of them or only some of them go to Nauru.
Senator, as I outlined, we're continually thinking about how this set of controls are operating, where they need to be adjusted, and should third country reception arrangements not be effective in controlling the community safety risk, we will continue to look at what options are lawfully available and, as needed, come back to the Parliament.
Can I just ask, I've just got a few more questions on this, but there was some evidence given that when these people go to Nauru, there's no right of return to Australia, but they can apply to go elsewhere. And I made the comment in Senator Pocock's line of questioning, could they come back to Australia? And I believe the answer was, and I'm happy for you to clarify this, it would depend on their circumstances. If they go to Nauru under this particular scheme, is there any possibility of them ever returning to Australia?
They would need a visa to be granted by Australia.
Yep.
So is there any possibility? I guess a minister one day into the future might decide to intervene and grant one, but it is hard.
So this does not close off the possibility that they could come back to Australia should a visa be granted.
Senator, any visa that one of these individuals might apply for would be subject to the character requirements in the Act that you'd be familiar with.
Yes.
This cohort, given their criminal records, it's very difficult to see.
But hold on, but you're not ruling it out completely. That's
no,
why
I mean, as Ms Sharp said,
yep.
It's theoretically possible that a minister in future
could intervene to override the character test, in effect.
Can I just ask very quickly, what is the total cost to date of administering the Community Safety Order Scheme?
I don't have figures on the Community Safety Order Scheme with me at this hearing.
I'll get them overnight then. I'll put them on notice for you. Thank you very much. What is the total cost of managing the NZYQ cohort, including legal and operational costs and any other costs?
Again, we did not come prepared to answer that. We need to take it on notice.
In the most recent budget paper number 3 at page 111, it shows the Commonwealth Government is paying New South Wales $7.1 million to assist in implementing the CSO scheme. Have any other states or territories signed on to a similar funding arrangement?
No, not as yet. No.
The answer is no, or we don't have the evidence.
The answer is no, no other states have. So that was in relation to Federation funding agreements that allow for that payment. To date, no other states have.
So it's just New South Wales.
Yeah.
So if you ever did get a CSO application up, there's no money then to be paid to the other states because there's nothing in place. What happens with New South Wales?
So with New South Wales, some of that funding goes around sort of capacity building. But that would be for if a detention order were made and the New South Wales government has entered into an agreement to house in one of their facilities someone subject to a detention order, they'd be housed and the Commonwealth would essentially cover the costs.
Okay. I've only got a few minutes left, so just very quickly to sum up this block of questions. What we're very much focused on here as a coalition is the safety of the Australian community. The bill, as we've heard, though, is about something different in the tight legal terms. It's procedural fairness in legal proceedings, and I accept that. But the issue we have is this. If we're focusing on the safety of the Australian community from murderers, rapists, pedophiles and a contract killer, we should be looking at options to put people back in detention, like preventative detention. But this bill, at this point in time, unless it's amended, doesn't do that.
The only thing I'd reflect on there, Senator, is that an efficient, well-functioning third country resettlement arrangement is absolutely consistent with the goal of protecting the Australian community. This bill is about supporting the powers that the government already has to enter into such an arrangement, to ensure that it can operate in the most kind of streamlined, effective way possible.
But in terms of the reason that we've been given tonight as the reason for urgently passing the bill is a potential hypothetical delay by the High Court case and a murder that is unaffected by this bill, because that was the reasons, I've got it here, that we were told that the bill needed to be urgently passed is in relation to the murder of this gentleman.
The bill will enable, it will reduce the number of legal arguments people might mount to try and frustrate their removal.
Just very briefly, Chair, one final block of questions. At Senate estimates on the 27th of March 2025, Senator Patterson asked about a case where a South Sudan-born man was sentenced to 14 months imprisonment by a Perth court. He pled guilty to 11 visa breaches. He referenced an AFP media release which said the judge ordered the man to serve 1 month in custody for the Commonwealth offences, then be released for the remainder of the term on a recognizance release order to be of good behaviour. This is despite the Parliament legislation for mandatory 12-month sentences for breaches. Can I confirm the department confirmed judges still retain discretion to suspend sentencing, and that a further amendment would be required if the Parliament wanted to remove that judicial flexibility in relation to these provisions? Is that correct?
That was the evidence I think we gave in March.
Was such an amendment contemplated as part of this bill?
Senator, I think you're asking me to comment on something that goes to advice to government, and I'd need to take on notice.
Can I just confirm, just very briefly, the department confirmed that it would be within the Parliament's power to amend the legislation in this way. So why not use the current bill to fix the legislation so that a 12-month mandatory minimum means what we wanted it to mean, a 12 months in jail, given that was clearly the Parliament's intent when it originally passed the laws?
Sorry, is there a question?
Yeah, it was. So why not use the current bill to do exactly what we know we need to do?
It's a matter for government which measures are put in bills.
Okay. What would be the simplest way to amend the legislation to fix that loophole?
I certainly can't.
No, I don't know. Can we?
We might put that on notice then overnight. One of the questions that I have here is, could you, for example, specify in the legislation that the sentence imposed must require the person to spend the entire sentence of imprisonment in prison?
Senator, I think you've just asked us to take on notice. The first question and your second question is a subset of it, I think, which is your question, if I heard it, was what is the simplest way to amend?
We looked at it, yeah. What is the simplest way to amend if we're looking to do something tomorrow? Can you confirm there is precedent for this in existing legislation? For example, certain people smuggling offences in the Migration Act are punishable by a term of imprisonment. They also set a non-parole period of 3 or 5 years. Is that correct?
Senator,
I'll get you to confirm that.
We definitely do not have briefing with us on the terms of those
confirm
provisions.
that overnight. Just in terms of, just give me 2 seconds, I'm going to move through these as quickly as possible. Oh, when did the department commence drafting the bill?
Mr Cunnington, do you know that?
I would have to take the exact date or notice.
Oh, weeks ago, months ago, days ago, just so I have half an idea in our deliberations tonight.
It would be late July in terms
Late
of
July,
drafting.
okay. Mm-hmm. Has the bill gone to the Solicitor General for his consideration?
No.
No, if the answer is no, it's not. We're looking at this bill tomorrow.
I don't want to mislead the committee, so I'll frame that, say not to my knowledge.
Not to your knowledge, okay. We'll put that on notice just so you can confirm it over the night. Can the department, and we've asked this obviously in relation to previous bills, and we're always told the answer is yes, assure the committee that there are no constitutional risks if this bill is passed by the Parliament? Well, no, I've got lots and lots and lots more, but I don't know.
You've got until
Senator,
7:26.
In response, the provisions that are prospective, modelled on provisions, there are other examples of prospective legislation that removes procedural fairness. The provisions that are retroactive are based on provisions that have been upheld by the High Court as valid fairly recently. The lawyers may wish to...
Yeah.
Sorry, I can't quite... You turned away from the microphone. Sorry.
With regard to the retrospective provisions, they're modelled on a High Court case, on some provisions considered in a High Court case called Australian Education Union and the Fair Work Commission. In that case, the High Court upheld the retrospective operation of those provisions.
Okay. Very briefly now in my time, just to help us tonight, how many NZYQ affected BVR holders are there as of today? Was that the 354?
That's as at the end of July.
End of July. Okay, end of July. Thank you very much. How many people have been re-detained awaiting deportation since being released on BVRs?
The 3 that were the subject of the interim third country reception arrangement.
Right, okay. And they're currently in detention?
That's correct.
Yep, okay. How many NZYQ affected detainees on the bridging BVRs are, as of today, subject to electronic monitoring conditions?
Senator, I have the end of July figures.
I'm happy with end of July.
Subject to electronic monitoring. Yep. That's 90.
90.
Yep.
Subject to specified curfew.
45.
Hold on, 45. Subject to both electronic monitoring and specified curfew conditions.
I don't have a figure for the overlap, I'm sorry.
That's okay. I'll put that on notice, so I will get that tonight. Of the total number of NZYQ affected individuals currently in the community as of July, how many have a criminal offending history of murder or attempted murder?
Senator, noting the interests of time, we did not bring a breakdown of. I'm conscious the opposition in the past has
I know.
Asked for a whole range of data. We don't have any of that with us.
But I'll put it on notice and you'll give it to me. Okay, so can I just close off on some evidence from Mr Biddington earlier? As I understand it, in relation to the operational capacity to notify and detain people once a visa has been issued, the evidence was that you would need, in effect, to be in a position to detain them immediately after noting them so they don't, I'll put it in very layman's terms, do a runner. Is that correct?
That's part of the consideration.
Yep. And given that your team would only have a limited capability and you need to take into account safety, how many people could you notify and detain, say, in a week if you needed to?
It would depend, Senator, on who those people were and the level of risk that those individuals posed.
How quickly could you detain 354 people?
Senator, I think that is a question that would... I alluded earlier to needing to do careful planning and sequencing. And
no, this is why I'm asking. Just
so
no,
we don't have an answer to that at this point.
No. I'm just going to get... No, if you had to do this tomorrow, though, are you talking weeks? Are you talking months? I mean, you'd have some understanding of what your operational capacity is, in particular in light of the evidence. So if suddenly overnight you were told, go and get 354 people, I mean, this for me, and in terms of, again, our deliberations, goes directly to the safety of the Australian community. We just need to understand the risks to the community, to your people, and how this is actually going to be affected.
And I don't think we have an answer. We would need to do, if we were directed to do that, it would require a lot of operational planning to ensure the safety and consideration of other things the Border Force is doing, reprioritisation of resources. It'd be a very complex equation, how much risk people were willing to assume. So I don't...
Have you done initial planning?
We've been working our way through various scenarios.
Right, okay. Oh, so you have... Okay, so you have... do you have any idea of how many people per year you could effectively detain on a pathway?
I don't have with me. I mean, I guess the best figure to look at is how many detentions we do in a year anyway, but this would be quite a novel situation and I don't have a figure.
Okay, I'm just going to quickly just go through. Ballpark figure?
No, Senator.
We don't have a ballpark figure. I've just got one more question.
Senator, if I may, just reverting to Mr Biddington's evidence, in each instance it is dependent on that visa being granted by Nauru first.
Oh, sorry. Thank you.
Yes.
Thank you. Sorry, you cannot start... until there's the visa, there's no ability to actually go and get them. So if there's never a visa, you can't go and get them unless, of course, you met the legal threshold for the detention order. Sorry, that was... yes, understood. So unless you had three... Sorry.
And if they were detained under, I think you just are mixing up the community order, safety order detention scheme, which would be being detained pursuant to that scheme.
Correct.
Wouldn't be being taken into immigration detention.
I was working it out in my own mind exactly. But the way, if you met the legal threshold under that, they could be detained, but you have to have all of the visas granted. If they were all granted tomorrow, ballpark figure, last question, how long do you think it would take to effect the detentions?
I wouldn't want to speculate on that.
Because careful planning is required.
That's right.
Okay. Thank you. You've been, as always, you give outstanding evidence. It's been under a lot of pressure tonight, so I really do, as always, appreciate. You always facilitate to the extent that you can the answers, so thank you.
Senator Shoebridge.
Thanks, Chair. So just to go back to the MOU, it's, to the best of your knowledge, it hasn't been published by Nauru, has it?
Not to my knowledge.
Right. It hasn't been published by your department, Ms. Sharp?
No, Senator.
Hasn't been published by any other government department that you're aware of?
Not to my knowledge.
Therefore not available to the public at the moment?
No, not to my knowledge.
Yeah, that's secret, isn't it? It's a secret MOU.
Senator...
It's a secret MOU, isn't it?
Oh, I think you're asking me to apply an adjective to describe it. Another way of characterising the sequence was the Minister and the President entered into an MOU. The fact of that was published a matter of hours after that. We're giving evidence about its contents 5 days after that.
Well,
so I'm not sure I'd agree with your characterisation of secret.
Well, is that because the Prime Minister rather awkwardly, despite it not being available anywhere to any member of the public, twice said about this MOU, there's nothing secret about it? Did anyone brief the Prime Minister on the fact that it wasn't available to anybody before he made that comment, there's nothing secret about it? He said it twice.
I don't have personal knowledge of who briefed the Prime Minister on what precisely, Senator.
Well, he's wrong, isn't he? Because it is secret, because it's not available to anybody.
I think it's your characterisation that it's secret. I don't think as an official I can comment on your characterisation.
Okay. Well, if nobody can see it, that pretty much meets the definition of secret. And you can tell me how I'm wrong in that.
I've already pointed out that the fact that it was executed was made public within hours of it being executed. We've given evidence about it for several hours this evening, but it's a matter for others to decide what meets the definition of secret or not.
Well, something no one can see normally meets the definition of secret, doesn't it, Michelle?
I don't think I've got anything further to add.
No. Well, could I think you said in answers to Senator Pocock that there hadn't been any consultation with civil society, and I think you said one of the reasons was you didn't want to prejudice any existing cases. Is that right?
That is broadly what I said, yes.
Yeah. And then I asked Mr. Frank how many cases we're talking about, and I think you said there were 3 that you knew of in relation to the natural justice under this legislation, and there was another unknown raft of unquantifiable number of other cases. Is that still the case?
That was in relation to Part 2 of the bill, Senator. So there are 3 in relation to the proposed amendments that deal with clarifying the procedural fairness does not attach to the third country reception arrangement and related processes. And then Part 2 of the bill deals with retrospective validation of decisions made prior to NZYQ. And so that was the part where it's a...
Were there any legal, tactical considerations in not giving notice about that law change, Ms. Sharp?
I guess my observation would be that on this kind of amendment, that are technical amendments to clarify the way we consider the law should be applying, we don't typically consult. It's not out of the ordinary that we didn't consult on the measures in this bill.
Well, I mean, we now have the benefit of at least some consultation because a number of key stakeholders have actually made their views known about this bill, and we've now tabled their views. Could I put this proposition to you from the Law Council and see if you disagree? The Law Council is also concerned with the retrospective application of certain provisions of this bill. This would appear to be contrary to the rule of law and will create significant uncertainty for many non-citizens in Australia. Do you agree with the Law Council that this is contrary to the rule of law and will create significant uncertainty for many non-citizens in Australia?
As I indicated to Senator Cash before, these provisions are modelled on laws that have been upheld by the High Court.
Well, their position is that retrospective laws are contrary to the basic rule of law. The presumption is that laws aren't retrospective. Do you agree with that?
The law, I do agree the laws will have retroactive effect if
and
passed.
that's contrary to the regular rule of law, which says people should know what the laws are at the time they're engaging in conduct. And as a general rule, parliaments shouldn't retrospectively make something legal or illegal.
I think the issue around the validation of laws, it's a really interesting point you're making, Senator. At the time decision makers made those decisions, they applied the law as it was understood at the time.
They were wrong.
That's right, but they were operating on the best understanding of the law that they had at the time. The effect of this amendment is to say that the decision isn't invalid because of them. If that was the only reason, it would be otherwise invalid.
It's to wipe out, for all intents and purposes, the High Court's decision on the illegality as found in NZYQ.
Senator, the way that the decision makers were
it's inconvenient,
talking,
isn't the High Court?
Senators, the way decision makers in the decisions that Part 2 deals with, prior to NZYQ, typically applied the law as it stood with Alcatel, was that they would find in favour of non-citizens that they were facing the prospect of indefinite immigration detention. Now, as it turns out, as the High Court has said in NZYQ, that's not correct. Instead, on a proper understanding of the law at the time, I mean, you can't realistically expect people to predict what the High Court's going to do, but on a proper understanding of the law, those people instead as a result of those decisions would have been required to be released from immigration detention.
We only have a short amount of time and a treatise, and I understand you're trying to be helpful, Mr Frank, but going a lengthy discussion of the impact of the NZYQ case is not going to be useful given the small amount of time. But you didn't ask the Law Council's views before this legislation happened.
Senator, I've already answered that.
So the Asylum Seeker Centre says about these laws, we believe the removal of legal rights from certain cohorts of people will have impacts beyond refugees and people seeking asylum, standing to marginalise multicultural communities and polarise public debate. This legislation risks entrenching the perception that certain groups are permanently conditional in their belonging, subject to different rules and denied the same access to justice. Such a move erodes trust in institutions not only among affected individuals but across multicultural communities who see these laws as part of a pattern of exclusion. Did you consider the impact on multicultural communities? Was that part of the consideration from the department in producing these laws?
Senator, we are firmly focused on ensuring multicultural communities feel safe and feel welcome in Australia. These laws, as we've been through this evening, clarify that procedural fairness is not owed in a situation that the common law currently agrees it is not owed. The duty to remove exists. There is no decision point that we think that the procedural fairness applies to as it is. We do think that having laws that provide certainty and clarity do support a cohesive community.
Well, it's not just the Asylum Seeker Centre. Hassan Musa, the Chief Executive Officer of the Arab Council of Australia, said these measures dangerously undermine fundamental rights, instill fear and send a disturbing message that migrants and refugees are held to a different standard of justice. And in this regard, he's saying they're having the basic right of natural justice removed from them. You didn't consider... Let me finish, Mr Scott. You didn't consider how these laws would be perceived in multicultural Australia? Did anyone in the department undertake that analysis before proposing these laws? Anyone at all?
Senator, what you're, I think, suggesting is that we should think about how proposed laws might be misconstrued or debated or expanded but through a public debate that is not about what these laws actually do. We're doing our best tonight to be clear on the very targeted and narrow scope of these laws, and hopefully through our evidence will help contribute to people understanding that they do not change their rights in the way that you're suggesting people are perceiving that.
Well, did you consider how these laws would be received by Multicultural Australia? It's a pretty simple question. If the answer is no, just say no.
Well, the answer is no. I did not consider the way that the impact that you're suggesting.
All right. Well, one of the concerns raised by the Human Rights Law Centre is the bill will preclude consideration of people's health, the harm they face in Nauru, and whether they will be permanently separated from family in making of third country reception arrangements. Now, all of those matters would normally be part of natural justice, wouldn't they?
So those matters were absolutely considered in the decision to cancel the person's visa. Once the person's visa is cancelled, they are subject to the duty to remove. These laws don't change that.
But you expressly allow yourselves to be able to make those decisions, to apply for a visa, deport somebody without considering the person's health, the harm they'd face in Nauru, or the separation from their family. You expressly exclude those considerations under natural justice, don't you?
Those things are aerated extensively through the primary decision phase, through merits review and through judicial review in the decision about whether that person should have a lawful right to remain in Australia.
Well, I'll give you one other example of natural justice that's been excluded. Nauru is a notoriously unsafe place for people who are LGBTIQ. Notoriously unsafe. In fact, I think Equaldex gives Nauru a rating of 43 out of 100 for LGBTQI plus rights. You never ask somebody whether or not they're likely to be subject to persecution for their sexual identity before deporting them to Nauru, do you? Because that's the natural justice rights you're taking away.
Senator, as we outlined, people will be given a notice of intention to remove. We are not blocking people's ability to claim protection, consistent with...
Well, they need protection from Nauru, which is the very place you're sending them.
And they can claim that if that's what they need.
But, well, can you provide us with a copy of this notice to remove? And can you provide the committee with a copy of one?
The notice to remove is issued to every person who is subject to the removal duty.
I'm sure there's a standard form, isn't there? So just provide a copy of the standard form.
There are several, Senator, yes.
Yeah. Do they invite submissions? Do they ask the person to make submissions?
No, it's a notice that they're going to be removed.
So they get a notice which doesn't invite submissions, and you're saying that they should, at that point, say, well, actually, being removed to Nauru will be exceptionally dangerous to me because Nauru I'll potentially be persecuted because of my sexual identity. They're just meant to... How are they meant to know to make that at that point?
Senator, I'm not saying they should make that claim. I am saying that if somebody has a reason that they think prevents their removal, there is an opportunity for them to tell us that.
Would they... Where would somebody in this process of deportation be able to say a woman who, for example, may wish to have reproductive rights, which are not available to them on Nauru, where would they be able to make that representation? Because that wouldn't be relevant to any of the prior decisions about cancelling of visas. Where would a woman be able to say, well, I don't want to go to Nauru, I will have no reproductive rights? Where would that kind of natural justice consideration happen in your world?
I'm not aware that a failure to provide access to reproductive rights would breach the Refugee Convention.
Right. So the fact that you would be sending people who identify as LGBTQI to a country where their rights won't be protected, and in fact they'd be at peril, that obviously that wouldn't... You're not going to be asking those questions. You're not going to be asking women about whether or not they should have access to reproductive health care. They're the very things that would come up under natural justice considerations that you're seeking to scrub, aren't they?
So, to clarify, Under the MOU, people will have access to healthcare, including if reproductive care. I'm not sure if you're getting at something different with reproductive.
Abortion is illegal in Nauru, and there's almost no production of no availability of that kind of healthcare to women.
Nauru, these people will be afforded the same access to healthcare as other people on Nauru. Nauru has a system for securing healthcare when it's not available on the island, and these people would have similar access to that.
Well, you're not suggesting that Nauru would facilitate rights to basic fundamental reproductive health, for example, abortion services, are you?
I'm
because it's illegal in Nauru.
People will be afforded the same healthcare as other people on Nauru. That is the effect of the visa.
And they'd be given the same almost absent protections for their sexual identity that apply in Nauru, where it's notoriously dangerous to be gay, isn't it?
I can't speak to that.
And you're not going to ask anybody, are you? You're just going to deport them. That's what removing natural justice is about.
Senator, we've repeatedly said we are under a duty to remove people who have no right to remain in Australia as soon as we reasonably can. That's what the Migration Act requires us as officials. Mm-hmm. We are not subject to that duty if there's a protection finding in place in respect of somebody. So if somebody was concerned about those things, they could make a claim for protection.
But they'd have to make a claim for protection from the very country you're sending them to, and they won't have any prior notice of it because you're stripping away their natural justice rights.
Leaving aside third country reception arrangements, we seek to remove people to countries and they make claims for protection on a regular basis. Yeah. What you're talking about is a scenario that can arise in respect of removal to anywhere in the world, and we take that seriously.
Okay. Well, one of the key things, of course, of this is normally before people are removed, they're given notice of it under natural justice, and that's what you're removing here.
Senator, that's incorrect. They're afforded natural justice in the visa process. They're not afforded natural justice when it comes to removal. It's a statutory duty.
Well, that's what's in debate in a series of cases, isn't it?
Not quite. What's in debate in the cases is whether the government was obliged to afford the three individuals procedural fairness in relation to entering into the international agreement with Nauru and then in applying for the Nauruan visa.
Ms Sharp, you remember on the last occasion, and I took you to it earlier, there were a number of figures given by Mr. I think it was Mr. Thomas at the time, about the people who would be potentially the subject to removal to a third country under those provisions, and I think I cited those figures to you earlier. Do you remember that?
Yes.
Could you please give an update of those figures as best you have them on notice for tomorrow morning?
Yep, certainly.
Thank you. And and I know we had a bit of back and forth about who would be the subject of removal or deportation, but I just might put this proposition to you based upon your answers and Mr. Thomas's answers on the last occasion. As at last year, there were approximately 80,000 removal pathway non-citizens, and any of them can be put on a third country removal pathway if their visa lapses or is cancelled. And in those circumstances, under this bill, they'd then be expressly denied natural justice in relation to third country reception arrangements.
Senator,
that's the situation, isn't it?
The first thing we do, if we have an unlawful non-citizen and they're not in immigration detention, the first thing, and we identify them, the first thing we'll seek to do is to work with them to regularise their visa status.
Got that?
So that could mean saying, do you want to, them saying, I've been in the community for 40 years and living here, we would look to work with them on what visa status they need to be regularised. If they have no right, there's no available visa for them because of, for example, they've exhausted every right and they've gone to ground, that's when they fall within the group of people who we'd say need to be removed. Generally, those people would be placed on a bridging visa E with the departure kind of condition attached. If needed, they could be placed in immigration detention while we worked with them to effect their removal. Most people depart.
Yes.
In the small group of people who need to be involuntarily removed, most are removed to their country of origin. The group of people in scope for a third country reception arrangement are that small group of people who cannot be removed to their country of origin and have no way of having a pathway in Australia. So it is not an 80,000 type of figure.
All right. Well, you tell me what the number is.
Well, the group, as we've talked about earlier, that the legislation was designed around, and that Section 76 AAA expressly references, are bridging visa R holders who have been granted a visa pursuant to a third country reception arrangement.
And because we don't have time, I'm not going to go through and repeat all of this other persons who fall within the definition of removal pathway non-citizen, being bridging visas, and other persons prescribed by the regs. Is there any intention, for example, to prescribe other persons under the regs?
I'm not aware of one.
Okay. But that's an open power, isn't it? It's not limited, the classes of persons who can be prescribed under the regs.
That's right. As we discussed in the hearings around that bill, that is a power available in future.
One of the reasons people may want to resist going to Nauru is, we've indicated before, because of their sexual identity. Is there a prohibition on Australia deporting people who identify as LGBTIQ+ to Nauru? Is there a prohibition on that, given the harm they face?
Not an express prohibition, Senator. However, as you're aware, Australia is a signatory to the Refugees Convention and other international treaties. And if, pursuant to those treaties, a person were to face a real chance of persecution or a real risk of significant harm if removed to Nauru, Australia would look to uphold those obligations and will not seek to remove that person.
But if someone falls into this cohort, you want to be able to deport them without giving them the right of natural justice to raise those issues.
Senator, these are people who've been through extensive visa processes we've already outlined. The department has extensive holdings on most of these individuals.
So are you saying that, yes, the department will deport people, even if they identify as LGBTIQ, and it's up to them to make an asylum claim to protect themselves? Is that the situation?
That's the way the Migration Act works. The Migration Act provides a framework for people to claim protection and for that claim to be assessed.
And one of the other reasons someone may want natural justice is because they may have a developing health issue that you weren't aware of. And by definition, if you're not aware of it at the time you make the proposal, it wouldn't be taken into consideration, would it?
No, it would be, Senator. I mean,
something you weren't aware of. How would that be taken into account?
We would likely become aware of it. That is because, like anyone who's taken into immigration detention, they'd have the opportunity.
But you would have already. You would have already made the deportation decision and got the visa. So, where in that process would they have a right to say, well, hang on, I've got, terminal cancer, or hang on, I have a need for this medical... They'd have
the opportunity to raise any health issues with their health services provider.
I think...
You're removing their right to raise that with you.
Senator, in our view, we are not removing the right. At common law, our view is procedural fairness does not attach to the removal duty. All this does is avoid doubt that we are required to afford procedural fairness either at the point when we enter into a third country reception arrangement or at the point we make an application for a visa on behalf of someone.
Yeah. If somebody has kids here, they can still be put on a removal pathway and deported even if they have kids here, can't they? That's not a protection?
The point at which somebody's connections to Australia, including children, is considered is at the point when the decision maker is weighing up whether their substantive visa should be cancelled or not.
So they have their substantive visa cancelled, they have kids here, they can be deported.
That is possible. If the decision maker weighs up the risk to the Australian community against all of the other factors that might weigh in favour of them being here, and they conclude that cancellation is still the appropriate response, that can happen. It goes through merits review, it goes through judicial review, and at the end of that, it is possible.
And then at the time you decide to deport them and to apply for a Nauru visa, they're not able to tell you that their kids may have a special need of them. They may have mental health concerns. They may have other health concerns. They're not you're expressly removing any natural justice rights for them to be able to tell you at the point of removal.
I think just to clarify, Senator, and I raised this before, we're not prohibiting them from raising information with the department. As Ms Sharp outlined, in some cases we will almost inevitably have secured that information ourselves if people are taken into detention, but this in no way prohibits people from raising information with the department.
It just gives them no rights.
It just clarifies
expressly
that natural justice is not attached to that particular action.
So it doesn't prohibit them, but it's just that they get no notice of the application. They're given expressly told that there are no rights to make submissions in relation to it, expressly told that this can all happen to them regardless of the impact on their families. You're expressly removing the right to give that information, aren't you?
The operative decision that removes their right to remain in Australia was the visa cancellation, where all of the things you're reflecting on were taken into account, weighed, had multiple points of review, and these individuals are on bridging visa removal pending. They have no right to remain in Australia.
We're caught in one of these secret, non-secret loops, aren't we? What would the natural justice rights be? What are the rights you're fearful of that you're removing then?
Well, our view is the rights do not...
I get your view, but you're putting legislation through. So if you were sure in that view, you wouldn't need this legislation, would you?
Just to take the two arguments in the
just
proceedings
answer my
before
first
the
question.
court.
If you were sure of the view, if you were sitting there, sure of the view that natural justice doesn't exist, why on earth would you bring this legislation and want to ram it through with no notice?
Because we want to clarify the law to enable the system to operate more efficiently and to not have it argued multiple times in multiple cases all at once.
So you want to remove any doubt that no natural justice applies. That's the nub of it, isn't it? You want to remove any doubt.
That's correct.
Okay. So if natural justice did apply, what's the mischief you're trying to correct? If the court said, actually, no, you're wrong, natural justice does apply, these cases are right, what's the mischief? What are the rights you're trying to extinguish?
On the primary argument in the TCXM proceeding, you'll recall it's that the government should have afforded individuals procedural fairness before entering into an international arrangement. As far as I know, that's unprecedented in this country. I really struggle to understand how practically a government could conclude an international agreement with another country while also having to consult potentially 54 individuals, and then also have those individuals be able to litigate the adequacy of that consultation for years before the agreement's concluded.
But of course, you also want those to extinguish those rights about the application for a visa too, don't you? And about the decision, once the third-party arrangement has been made, about the decision to put someone on that pathway. You want to remove natural justice from those aspects too, don't you? With this bill.
In relation to the process to apply for the Nauru.
So what are the natural justice rights you're trying to extinguish?
Well, we don't think there are any.
Well, for the avoidance of doubt, what are the ones you're fearful of?
Senator, when the bill passed last year, natural justice was excluded at the point we thought it would be applied. That's in section 76 AAA, I think it's subpara 5. Procedural fairness was excluded from this scheme in recognition of the fact that these individuals have had multiple opportunities to make the kinds of arguments you're...
No, Ms Sharp, I get it that you think it doesn't apply. But there's a bunch of cases saying it does apply to the visa, application for a visa and decision to put someone on deportation pathway. And I'm asking you, if it was found to apply, what are the rights that they would have that you are so fearful of?
It's a bit of a hypothetical question in the sense that procedural fairness, the content of that obligation, is dependent on the particular statutory scheme you're dealing with.
But to be given notice of it and to be allowed to make submissions about it, they're pretty core elements, aren't they?
But about what, Senator?
About the decision to deport you to Nauru, about the decision to get a visa for Nauru.
We don't even know that Nauru would grant the visa to that particular individual.
The decision to make an application for a visa to Nauru. You're trying to send them to Nauru. They have a right under natural justice What these cases are saying, before you send them to Nauru.
Senator,
And that's what you're trying to get rid of.
Under Australian law, natural justice or procedural fairness normally attaches where a person's rights, interests, obligations are affected under Australian law. An application for a Nauruan visa does not have any effect on a person's rights, interests or obligations.
And a
under
decision
Australian
for an
law.
Australian government
And
official
that's
to
what the federal
apply
court-
for a visa on their behalf.
Indeed, and that's what the federal
Okay.
court found in
Well-
TCXM.
We've hit the marker, Senator Shoebridge. Thank you very much for your time this evening and for going beyond what we thought we might be here for. So I appreciate your time. That concludes today's proceedings. The committee has agreed. 10 p.m. 10 a.m. The committee has agreed that answers to questions on notice taking at the hearing should be returned by 10 a.m. tomorrow morning.
Thank you.
And of course, best endeavours, noting that it is a tight turnaround for you and department officials. And I want to thank you again for appearing tonight. And thanks to Broadcasting and the Secretariat for your time too. I declare the hearing adjourned.
Thank you.